Orlando Police Department. Robert Roberts, Orange County Sheriff's Office. Paul Foster, Orlando Police Department. Deputy Chuck Ashworth, Orange County Sheriff's Office. Cleveland Jenkins, United States Marshal Service. Dr. Joshua Stephanie, Office of the Medical Examiner. Chantel Steyer, Orlando Police Department. Karen Livengood, Orlando Police Department. Detective Shane Overfield, Orlando Police Department. Darlene Dunn. Edward Vanderberg, Orlando Police Department. Gary Crosby, Orlando Police Department. Sean Johnson, Florida Law Enforcement. Andrew Harrison, Orange County Sheriff's Office. Dr. Sarah Zidovich, Office of the Medical Examiner. Richard Ruth, Florida Department of Law Enforcement. Tracy Anderson. Officer Jonathan Cute, Orlando Police Department. Ronald Stewart. Dr. Michael Gamache. Detective Adam Crudo, Orlando Police Department. Dr. Michael Mayer. Marianne Mitchell. Deputy Rachel Ward, Orange County Sheriff's Office. Dr. Tanya Werner. Todd Erb. Earl Stokes. DeCarlos Shepard. Howard Kuhn, Orlando Police Department. Theophilus Edwards. Brian Stribby. Ronald Guerrero. Latoria Washington. Francine Thomas. Tammy Hughes. Dorothy Patterson. Tanya Cowan. Regina Hill. Dr. Robert Buck. Tamara Coker. Jim or James DePalma. Dr. Emily Lazaro. Rodney Lamond. Dr. Jeffrey Nagin. Dr. Jacqueline Olander. Dr. Greg Pritchard. Tony Rowland. Dr. Joseph Sesta, and Kevin Whitmore.
Thank you, Mr. Williams. Does anyone recognize Mr. Williams, Mr. Butzman, or any of the witnesses whose names were read out? Juror in seat number 23. Okay. Yes, ma'am. Who do you recognize? Okay, and how do you know her? Okay. Is there anything about your, do you still maintain contact with her? Okay. Is there anything about your prior relationship with her that would affect your ability to be a fair and impartial juror?
No, at the time we were former workers at one Walmart, and she went to the one where the incident happened. We were no longer in contact.
Okay. All right. Thank you, ma'am. Seat number 4. Yes, sir. Who do you recognize? Who?
Todd Erb.
Todd Erb. Okay. How do you know him?
Former coworker at a
Do you still maintain contact with him?
No, we are friends associated enough.
Is there anything about that relationship that would interfere with your ability to be fair and impartial? All right. Thank you, sir. Anyone else? All right. To my left is the defense team. Mr. Lenneman, if you'd introduce your team and read your witness list, please.
Yes, Judge. Good morning. My name is Terry Lenneman, along with Cato Shea and Morero. We represent Markeith Loyd. Patricia Loyd, Dina Loyd, Tanya Loyd, Adele Jones, Barry Jacobs, Deanna Loyd, Damian Hilton, Eric Harris, Eric Dorsey, Glenn McCree, Lincoln Harp, Jackie McCree, Giovanna Lloyd, Jesse McCree, Shanika Bush, Shanika Hahn, Irene Wesley, Pat McKenna, Dan Dolsky, John Sawicki, Anna Cox, Dr. Jethro Toomer, Dr. Marvin Dunn, Dr. Michael Mayer, Dr. Joseph Blue, Dr. Jeffrey Polino, Dr. James Campbell, Dr. William Anderson.
Thank you, Mr. Lenneman. Does anyone recognize Mr. Lenneman, Ms. O'Shea, or Mr. Marrero, or any of the witnesses whose names were read out? I don't see any paddles. Does anyone recognize Mr. Loyd? Hold your paddles up. All right, until I call your numbers, please leave them up. 1, 2, 7, 10, 11, 12. 9, are you up or down? Oh, 10, all right, 10, 11, 12, 13, 14, 16. Once I call your number, you can put them down. 18, 19, 21, 23, 26, 27, 28, 39, 32, 39, and 40. Did I miss anybody? 9. Okay. All right, of those of you who raised your paddles, please don't say anything, folks. I just need you to raise paddles in response to this. How many of you have formed an opinion as to whether or not Mr. Loyd is guilty? Please raise your paddles. Juror in seat 2, 1, 12, 13, and 14, 16, 18, 19, 21, 26, 27, 28, 32, 39, and 40. 9. Seat number 9. Sir, do you speak English? Not much? Okay. Did you understand my question? Not really? What is your native language? What is your native language? Do you speak Spanish? Okay. How much English do you understand? Not much? Okay. All right. Thank you. Anyone else who has problems with English, since I'm on that topic? No. Okay, thank you. Ma'am, this is seat 15. Ma'am, what language do you speak? Do you speak Spanish? Yes? Okay, thank you. Anybody else? All right. Do any of the jurors know each other? Look around. This happens more often than you think. All right. I don't see any paddles on that one. All right, folks, let me tell you a little bit about the process this morning. This is a death penalty case, meaning it's a capital case, meaning death is a possible penalty in this case. There is no automatic death penalty in the state of Florida. This is just a possible penalty in the case. So we do this we normally do these jury selections. We spread them out over several days. Today, I believe, is the final day of jury selection, so we're actually going to compress the jury selection that we normally do on day 1 and 2. We're going to compress it into today. So I'm going to do this in stages for a variety of reasons. Before I start that process, I'm going to give you all a jury instruction that is an actual court order, and that is this: from this moment forward until you are excused as a juror in this case, discharged as we call it, you are not to discuss this case with anyone. You are not to look anything up. And anyone means your fellow jurors also, because there's going to become a point when you're going to be in a different courtroom, waiting just in a holding area, waiting to be called back into this courtroom. You are not to discuss this case with anyone. You are not to look up anything about this case. You're not to watch anything, videos, nothing about this case. You are in a cone of silence. The reason for that is very simple. In our criminal justice system, we have a sense of what is fundamentally fair and what isn't. People have a right to know what they're charged with, and both sides, the state and the defense, have a right to know what evidence is being considered against them by a jury in making a decision. When jurors are out exploring on their own, we have no way of knowing what information you've gotten, and we have no way of knowing if it's even accurate. Jurors are limited to making decisions, rendering verdicts based solely on what they hear in the courtroom, because both sides have a right to present contrary evidence, explain that evidence, buttress that evidence. Both sides have a right to know when you go back in a jury room what it is that you're using to make a decision about whether or not someone is guilty of a crime. It is fundamentally unfair for jurors to step outside of that. I will sanction any juror who violates the order I just gave. So stay off your phones, stay off your laptops. You're either going to be discharged as a juror today or you're going to the final round of questioning on Monday. So I'm going to take all the mystery out of this for you right now as to what's going to happen. I'm going to ask you a few basic questions that I'm going to send you all out of the room and start bringing folks in at one time. So I'm going to do this row by row just to make it easier on everyone to keep track. So starting with number 1, which is this side of the courtroom, through number 7, which is the first row on my left. Is there anyone in that row whose employer does not pay them for jury duty? You do not get paid. Just the first row. We'll be with you in a second. All right, I don't see any paddles. Jurors 8 through 14. Oh, 5. Yes, ma'am. That counts. All right. Part-time job, self-employment, all of it counts. So if you're in jury duty, well, let me back up because I forgot to tell you all this part. Sorry, it's been a long week. This jury is being sequestered. And by sequestration, I mean, once you're selected as a jury, we're going to put you up in a hotel. It's not as bad as it sounds. It's a very nice hotel. Somebody's going to feed you 3 meals a day, cook, clean up after you. Every one of you gets your own room. You do not have to share rooms. Someone's going to make your bed, change your sheets, change your towels. But you will be in a hotel. You can bring your electronics with you. Access to electronics is limited to a very large room that we have for you where the deputies will be there. The only reason being they need to make sure no one's trying to email you or talk to you about the case. You'd be amazed at how often people want to share their opinions with jurors about the cases the jurors are hearing. You can do work after we're done in the courtroom. You can, if you're a student, you can do your classroom work. You can Zoom call with your family. We do make arrangements for you all to see your close family. That would be spouses, partners, children. There are things for you to do at the hotel when you're not in jury service, but you are sequestered. We work from 9:30 to 5:30, Monday through Friday. We'll stay a little bit later if someone's on the stand testifying. And we work half a day on Saturday from 9 to 1 in an effort to move the trial along because you are sequestered. So now you've got all the pertinent facts to this question. So, ma'am, you're not getting, you have a part-time job, is that correct? Okay. And if you are not working at that job, are you making any money? Okay. And can you pay your bills without that income? All right, thank you. Anyone else from 1 through 7? All right, 8 through 14, same questions. Anyone whose employer does not pay them? Juror in seat number 12, do you get paid at all, or just, you can put it down once I call your number. Yes, ma'am.
Do I get paid at all?
No? Okay, can you pay your bills?
No.
All right, thank you, ma'am. Juror in seat number 14, yes, ma'am, do you get paid at all? All right. Anyone else whose employer does not pay them? All right, jurors in seats 15 through 21, employer does not pay you. Juror in seat 16, yes, ma'am, you don't get paid? Can you pay your bills? Okay. Juror in seat 17, do you get paid? Can you pay your bills? Thank you. Juror in seat 18, do you get paid? Can you pay your bills? Juror in seat 19, do you get paid? Can you pay your bills? All right. Anyone else in that row? All right, jurors 22 through 28, anyone who does not get paid. Juror in seat 22, do you get paid? Can you pay your bills? All right, thank you. Seat 23, ma'am, do you get paid?
I'm not sure, they said I would, but I do everything online, so it doesn't tell me what I will.
Okay, is there someone you can call during a break to find out? Okay, great. During seat 25, yes, sir, do you get paid?
I don't know, I just started this job,
When you say you just started this job, how long ago was that? All right, so you can call and find out during a break? All right. Anyone else in that row? All right, seats 29 through 34. Anybody who doesn't get paid? 29, do you get paid? And can you pay your bills? Thank you. 30, do you get paid? Can you pay your bills? Thank you. Juror in seat 34, do you get paid? Can you pay your bills if you're not being paid? You can? Okay. Jurors in seats 35 through 40, any of you who do not get paid? Juror in seat 35, yes ma'am, do you get paid? Can you pay your bills? Okay. Anybody else? 38, do you have your paddle up or no? Or you don't, you're not sure? Is there someone you can call during a break? All right, thank you. Is there anyone, and again, I'm going to do this by rows, anyone who has child care issues that they could not resolve if you were sequestered for 2 to 3 weeks? I'm going to do it by row, ma'am. Row 1 through 7, 8 through 14, 13, yes, sir. What have you got? Or, okay. Is this your first child? Congratulations. Is it a boy or a girl? Okay. Juror in seat number 12, yes, ma'am.
My daughter and I take care of my grandson. He was premature. He has a swallowing defect.
Okay,
So he can't get to
all right. And if you're not there to help her, is there anybody else who can take over? No? All right, thank you, ma'am. Anyone else or in that row? 15 through 21, child care issues. All right, 16, yes, ma'am.
I have 2 children that go to school, but I am the only person who is I do not have anybody. My husband works full-time and I do not have anybody.
How old are your children?
The youngest is 6 and the oldest is 12.
Okay, thank you. 17, did you raise your paddle? Yes, sir. Yeah.
I just pick up my granddaughter and teach her.
And what happens if you're not available to pick her up? I'm sorry? Okay. Thank you. Anybody else in that row? 22 through 28. Nope. 29 through 34, 29, you raised your paddle. Yes, ma'am. And what happens if you don't, are you a single parent? Okay. So what happens if you can't do it? Okay. Anybody else in that row? And then 35 through 40? 40, yes, ma'am. Do you have any other family in the area? Okay, thank you. All right, is there anyone who's responsible for a dependent, who's an adult? Parents, dependent children who are adults, anybody who's doing that? All right, from 1 through 7, anyone who has a vacation that is already paid for and scheduled in either October or November. Juror in seat number 1, yes, sir. For how long? Okay. And where are you going? And it's all paid for? All right. 4, are you raising your paddle? Yes, sir. What have you got? You'll be able to go to a football game tonight. That's not a problem. No, jury's being selected on Monday. You'll have to come back Monday. But which football game are you going to? Okay, that's okay. All right. Juror in seat number 6. Okay. All right, thank you, sir. Anyone else in that row? Jurors in seats 8 through 14, vacation already paid for. Juror in seat 11, yes, ma'am. Thank you. Seat 12, yes, ma'am. From the 20th? That was, 28th. I was thinking that was yesterday. 28th through the 31st. All right, thank you, ma'am. 14, yes, ma'am. Okay, thank you. 15 through 21, vacation already paid for. 21, yes, sir.
November 10th, 11th, 12th, volume of 12.
Thank you. 22 through 28, anybody? 26, yes, ma'am. All right, thank you, ma'am. Anybody else in that row? 29 through 34, vacations. 29, yes, ma'am. When? Thank you. 31, yes, ma'am. A lot of people getting married. 32, yes, sir. Thank you. 35 through 40, vacation, already paid for. 36, yes, ma'am. Okay. Thank you. Juror in seat number 40, yes, ma'am.
November 5th to 7th, the bachelorette party at Airbnb paid.
All right, anybody else that I missed? Everyone in this courtroom can sympathize with work piling up on your desk while you're in a trial. We understand, we sympathize. It's not a legal reason for me to release you from jury duty. So my question is not whether you have work that's piling up. I understand that. My question is there anyone who has a special project at work, something going on that you are the only person who can do it? And this would interfere with it. Juror in seat 36, yes, ma'am. I heard I'm a small business owner and something about COVID. Yes, ma'am? Yes? And what happens if you're not there? So it would be a financial hardship? Okay. Anyone else? Juror in seat 17. Yes, sir.
I'm a sole proprietor, contractor, I'm managing project folder. I'm not there, something gets done. Next year, penalty hardship, only have 2 jobs. I can't meet production.
You're talking about construction projects? This has nothing to do with the question I just asked you, okay? Because you just told me that you have to be there, but are you able to get supplies for any of this, for these projects? Are you able to get supplies for your projects? Okay. All right, who else? Somebody over here raised it. 28, yes, sir? Uh-huh. Okay. Are you in IT? No. Okay, so you have to put up, really, they're having you put up Christmas decor in October? Okay, but you'll lose your promotion if you don't go? All right, thank you. Someone over here, oh, juror in seat number 2. Yes, ma'am. So do you know, when's your interview for this? So are they do you know when they're gonna tell you whether you got it? Okay. And then you would start this new job on November 1st, you said? All right, thank you, ma'am. Anyone else? All right, anybody who has an issue that I haven't asked about, I just haven't thought of it, but it's unique to you. Yes, sir, juror in seat number 34. Okay. Is that something that can be rescheduled or not? All right, you don't need to tell us what it is, sir. That's fine. Anyone else who has medical issues? Juror in seat 12, yes, ma'am. Okay. We take breaks during trials, usually every hour to hour and a half, but the rest of the time you're sitting. Is that not going to do it? You're shaking your head no, remember?
Sorry, no.
Yeah. I knew eventually I'd catch one of you. Go ahead.
No, I literally have to.
Okay, thank you. Juror in seat number 4, yes, sir. Okay, thank you. Juror in seat number 3. Are you a full-time student, sir? Are you online or in person? Are you asking for an exemption from being a juror this time? Are you asking to be excused? Okay. Are you getting any sleep? Because this gentleman over here is not. Okay. All right. All right, thank you, sir. Anyone else who has medical issues, anything like that, that would prevent you serving as a juror? All right, folks, we're going to take a quick break, follow the directions of the deputies, don't talk about this case. Those of you who don't know whether you're getting paid, please call your employers so you can answer the question when you come back in. All right, thank you. Did I see one? Who is that? No, actually I didn't. Okay. Seat 27. Yeah, seat 27, juror number 14 is a corrections officer. So I'll get to him in just a second. I just want to let you all know. All right, starting with seat number 1, he's got a vacation Friday through Tuesday. I'm sorry? Yeah, I'm going through that.
Mr. Lemony is, without having to speak at all.
Okay, sure, no problem.
Yeah, I spoke to him.
All right, so I'm going to go with this. Seat number 1, he's got a vacation Friday through Tuesday. Any objections? Yes, you can, sorry. Yeah, Mr. All right. Seat number 2, trip for something on November 1st. Oh, no, up for a promotion on November 1st. Any objections on 2? She's up for a promotion on November 1st. She would lose the promotion if she was here. All right, she's gone. Seat number 3, full-time student, excused by statute. Seat number 4, I have more jurors downstairs, by the way. Seat number 4 knows one of the witnesses and has a custody battle for his son and lots of meetings scheduled with his lawyer. Custody battles in December. State? Defense? I'll bring him back. I don't have a problem with that. Okay. All right, I'll bring him back. Seat number 5, I got to bring him back in. They're asking me to, I'm going to bring him back in, all right? Because honestly, I've gotten minimal information from him. Seat number 5, she has a part-time job, can't pay her bills. Any objection from state? Defense? 5. Okay. 6 has vacation Thanksgiving week, I'm bringing him back. 7 said nothing, 8's back. 9 doesn't understand English. Any objection, state? Defense? No. 10 is coming back. 11 has a vacation November 11th through the 15th. State? Okay. 12 is the lady who can't pay her bills. I'm just talking about that right now. Any objection, state? Defense? No. All right. 13 is the gentleman with the 4-month-old and sleep deprivation. State? Okay. 14 has a Vegas wedding from November 17th through the 20th. Okay. 15 can't speak English. No, any objections? 16, she has a 6-year-old and a 12-year-old. Her husband works. She drops off and picks up. State? 17 picks up his grandson, but he can't pay his bills. Based on the can't pay his bills, state? 18 can't pay bills, state? 19 can't pay bills. 20's going through. 21 has a vacation from November 10th to the 12th. Any objection? 22 can't pay bills. Any objections? 23, not sure. She's going to call, so I'll wait till she comes back. 24 is going through. 25, not sure whether he can pay his bills, but he's the one that started a new job last Monday. So I'll bring him back in to talk to him. 26 has vacations November 11th and I think October 29th. She's going to Cancun. So, any objections? All right. She's also one of the ones that had an opinion. So 27's going through. 28 is going to, his promotion's based on being at the Bahamas next week to start Christmas. Any objection? I'm sorry? No? Okay. All right, he's gone. 29, can't pay her bills. Any objections? 30, can't pay the bills. Any objections? 31, has a wedding November 5th through the 8th. 32 has trip to Salem November 9th through the 13th. 33 is going through. 34 has a medical appointment he can't miss next Thursday. 35 is going through. 36, small business owner and has financial hardship and a South Carolina trip plan. 37 going through, 38's calling, 39 going through, and 40 has the bachelorette party from November 5th through the 7th. Okay, so let me go back through here and see how many of the have an opinion have been struck. 11 has been struck. 12, 13, 14, 16, 18, 19, 21, 27 still here, 39 still here. All right, so the ones I have showing that have an opinion and have not been struck are 27 and 39. And we have, knowing about the case, 7 and 10. So I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. I have 14 left. I have 12 downstairs. You want me to bring the other 12 up? Might as well eliminate them now before we start the individual portion of the proceedings. All right. Can you tell them to send me the next 12 up, please? And while they're getting that one assembled, if I could see juror in seat number 27, please. This is juror number 14. He is a corrections officer. Yes, he's an Orange County Corrections Officer. This is juror number 14 in seat 27. Morning, sir. You're juror number 14, is that correct? All right. You indicated that you knew about this case, is that correct? Have I noticed that you work for Orange County. Have you had contact with Mr. Loyd at the Orange County Jail? All right. Have you formed an opinion about Mr. Loyd's guilt in this matter? And what is that, sir? All right, you have to be able to presume him to be innocent in order to sit as a juror in this case, until and if the state proves he's guilty. Do you think you could do that, or would you start the trial believing him to be guilty? Okay. All right, thank you, sir. State? Defense? All right, thank you, sir. You're excused and you're free to go. Juror in seat 39. This is juror number 13. Good morning. You're juror number 13, right? All right, so you indicated that you had some knowledge about this case, is that correct?
Yeah.
Okay. And that based on that, you'd formed an opinion as to whether or not Mr. Loyd was guilty, is that correct? Okay. Let me tell you what I tell all jurors. The questions that we ask you, there aren't any right or wrong answers to them. We're just trying to find out if folks can do their job as jurors in these types of cases. So the only correct answer is the truth. So don't worry about your answer, just tell us the truth. So you said you somewhat have formed an opinion about his guilt. Well, what is the opinion you have?
Well, that he's guilty. I mean, it's difficult to have a different opinion based on
Okay.
but I don't know all the facts in the case. I'm not guilty.
All right, so here's how this works. In order to sit as a juror in any criminal case, you have to be able to presume someone to be innocent until and if the state proves they're guilty beyond a reasonable doubt. So I'm going to give you 3 scenarios, and you tell me if any of these apply to you. And if none of them apply, just say that, okay? The first scenario is it's the first day of the trial. You're sitting over here in the jury box. We haven't even started. You're just sitting there waiting for us to start. And you're thinking, this gentleman's innocent and the state needs to prove to me he's guilty beyond a reasonable doubt. Scenario number 2 is you're sitting there thinking, I'm pretty sure he's guilty, but I'm willing to see if I'm wrong. Scenario number 3 is he's guilty and he's going to have to prove to me that he's not. Do any of those 3 apply to you? Number 2? Okay, thank you. State. Defense. All right, thank you, sir. You are free to go. So let's go ahead and release the folks that we've already struck, which is you can release the jurors in seats 1, 2, 3, 5, 9, 11, 12, 13, 14, 15, 16, 17, 18, 19, 21, 22, 26, 28, I've already released 27, 29, 30, 31, 32, 34, 36, I've just released 39, and then 40. If you'll release all of those and tell the others I'll be right with them, because I have more jurors coming up. I have 3 jurors who indicated they knew something about the case, but hadn't formed an opinion yet, 7, 10, and 23. I haven't instructed them though, so I'm not going to bring them in right now because they haven't gotten the second part of the instructions. How are we doing on the next 12? All right. This panel right now that we're talking about is panel 11. The next panel is panel 12 for record purposes. So I have left 7, 10, and 23 that had an opinion, right? Didn't say anything, but not, it didn't have an opinion, but had heard about it. Okay, great. Thanks. I just want to make sure I have the right numbers. Okay. The 12? Whatever's easier for you guys. You can just leave them in 4C because I'm just going to bring these 12 in, and once I'm done with these 12, oh, I see what you're asking me. Maybe we can put these 12 in that jury. No, that's not.
No, but once we pick 10 and 11, I can put them in 19.
Yes. I'm sorry, I'm a little slow this morning. I get what you're asking me.
So they're not hanging around with the other 12.
Can I see the attorneys up here for a minute, please? All right. Is everybody here? We ready? No? For 12 people? Okay. We're back in session on State versus Loyd. He's present with his attorney. State Attorney's Office is present. This is panel 12.
Ladies and gentlemen, all cell phones, smartwatches, laptops, iPads, please turn them off and away from me. When I call your number, please come forward. 47. 88. 145. 100. 147.
Yes, ma'am.
124,
I got it. Thank you, though.
37, 136, 21, 2141.
I really wasn't born with this kind of thing.
Stand, raise your right hand the best you can, and face the clerk to be sworn out for me. You can sit. Everyone else, please stand, raise your right hand, face the clerk to be sworn.
Do each of you solemnly swear to answer truthfully all questions asked of you as prospective jurors so help you God?
All right, have a seat, everyone. Good morning, ladies and gentlemen. Welcome to jury selection. This is Circuit Criminal Court. I'm Judge Marquez, and I'm going to be the presiding judge in this case. Jury selection today is going, how many of you have ever been through jury selection before? Okay. It's going to be a little bit different today, but I'll explain that to you in just a minute. Let me go through some preliminary matters with you. First of all, there is going to be media presence throughout this case. Don't worry about it. Just ignore it. They don't film jurors. They don't publish your information. We've given you paddles with seat numbers on them, and we do that for two reasons. Number one, because that way we don't have to use your names during jury selection. It preserves your privacy. We'll refer to you by your seat number. And number two, referring to you by your seat number makes it very easy for us to find you on the chart that we have and know which jurors answering questions. So before I get started, let me explain to you and see if you recognize anyone who's here, what everybody does here. I'm the presiding judge. I'm Judge Marquez. My job is to make sure that the law is followed in this case. I'm the one that instructs the jury on what the law is in the form of jury instructions. I also rule on objections during the trial. I rule on what evidence is admissible. Is there anyone here who knows me or recognizes me from anyone? Not seeing any paddles. All right. To my right, these two ladies are the clerk. They work for the clerk of court's office. It's their job to keep track of all the evidence, the exhibits, the documents, everything that we need during a trial. Is there anyone here who knows either of these two ladies? Not seeing any paddles. The folks in uniform scattered around the courtroom. These are members of the Orange County Sheriff's Department. They are courthouse security. They're here every day in all of the courtrooms in the courthouse. It's their job to provide security. They also, as you have noticed, escort jurors in and out of courtrooms. If you have an issue during a break that needs to come to my attention, let the deputies know and they'll let me know. Is there anyone here who knows or recognizes any of our deputies? Nope. Okay. The lady in the front typing away is our court reporter. It's her job to keep an accurate record of everything that's said in this courtroom. And you're going to make her job a lot easier if you speak up when you're answering questions. Most folks hate public speaking, and I understand that, but she has to be able to hear you in order to take your answers down. So please speak up so she can hear you. Also use words when you're answering questions. Court reporters cannot take down people shaking their heads yes or no, or shrugging their shoulders, and and make no sense to us when we see them typed out on a piece of paper. We can't tell if you're saying yes, no, or maybe. Anyone here who recognizes or knows the court reporter? No. Right. To my right are the gentlemen representing the state of Florida. If you all would introduce yourselves and read your witness list, please.
My name is Ryan Williams, and Mr. Buxman and I are the assigned assistant state attorneys designated to try this case. If you're selected as a juror, we will call, or may call, the following witnesses: Dominique Daniels, Detective Brian Savelli, Orange County Sheriff's Office; Timothy Stevens, Takeshia Bryant, Julia Johnson, Monica Pridgeon, Patricia Monahan, Sean Williams, Orlando Police Department; Detective Pete Cadis, Orlando Police Department. Officer Brandon Thornton, Orlando Police Department. Captain Joseph Carter, Orange County Sheriff's Office. Antoine Thomas, Peter Patrick, Stacy Monroe, Orlando Police Department. Deputy Robert Roberts, Orange County Sheriff's Office. Paul Foster, Orlando Police Department. Deputy Chuck Ashworth, Orange County Sheriff's Office. Cleveland Jenkins, United States Marshal Service. Dr. Joshua Stephanie, Office of the Medical Examiner. Chantel Steyer, Orlando Police Department. Karen Livengood, Orlando Police Department. Detective Shane Overfield, Orlando Police Department. Darlene Dunn. Edward Vanderberg, Orlando Police Department. Gary Crosby, Orlando Police Department. Sean Johnson, Florida Department of Law Enforcement. Andrew Harrison, Orange County Sheriff's Office. Dr. Sarah Zadovich, Office of the Medical Examiner. Richard Ruth, Florida Department of Law Enforcement. Tracy Anderson. Officer Jonathan Hughes, Orlando Police Department. Ronald Stewart. Dr. Michael Gamache. Detective Adam Crudo, Orlando Police Department. Dr. Michael Mayer. Marianne Mitchell. Deputy Rachel Ward, Orange County Sheriff's Office. Dr. Tanya Werner. Todd Erb. Earl Stokes. DeCarlos Shepard. Howard Kuhn, Orlando Police Department. Theophilus Edwards. Ryan Stribbe. Ronald Guerrero. Victoria Washington. Francine Thomas. Tammy Hughes. Dorothy Patterson. Tanya Cowan. Regina Hill. Dr. Robert Buck. Tamara Coker. James DePalma. Dr. Emily Lazaro. Rodney Lamond. Dr. Jeffrey Nagan. Dr. Jacqueline Olander. Dr. Greg Pritchard. Tony Rowland. Dr. Joseph Sesta, and Kevin Whitmore.
Thank you. Does anyone recognize Mr. Williams, Mr. Buxman, or any of the witnesses whose names were read out? I'm not seeing, oh, juror in seat number 3. Yes, sir. Okay. Is there anything about your friendship with that? Is there anything about your friendship with that family that would affect your ability to be fair and impartial as a juror? Don't know? All right, we'll be asking you more questions about that. Thanks for letting me know. Anyone else? All right, to my left is the team representing the defense, Mr. Linneman.
Good morning. My name is Sade Dixon, along with Kate O'Shea and Tim Marrero. We represent Markeith Loyd. Witnesses: Patricia Lloyd, Dana Lloyd, Sonia Lloyd, Adele Jones, Barry Jacobs, Deanna Lloyd, Damian Moten, Derek Harris, Eric Dorsey, Len McCree, Lorraine Hart, Jackie McCree, Ivana Lloyd, Jesse McCree, Shanika Bush, Shanika Hobbs, Irene Wesley, Pat McKenna, Ann Doski, Melissa Leakey, Anna Cox, Dr. Jeffrey Toomer, Dr. Marvin Dunn, Dr. Michael Mayer, Dr. Joseph Wu, Dr. Jeffrey Polino, Dr. James Campbell, Dr. William English.
All right, thank you, Mr. Linneman. Does anyone know or recognize Mr. Linneman, Ms. O'Shea, or Mr. Marrero, or any of the witnesses whose names were read out? All right, by a show of paddles only, is there anyone here who recognizes Mr. Loyd? Raise your paddles if you do. Juror in seat number 2, 5, are you up? Is your paddle up? 5, 8, and 12. Anybody I missed? All right, you put those down. those of you who raised your paddles, without saying anything other than raising your paddles, has anyone formed an opinion as to Mr. Loyd's guilt based on what you know? Raise your paddles if you have. Juror in seat number 12. Anyone else? All right, thank you. All right, folks, let me give you, oh, you know what I forgot to ask y'all? Do any of you recognize each other? Nope, okay. All right. You're here for jury selection, as I said. This case is a death penalty case. It's a capital case. And what I mean by that is death is a possible penalty in this case if a number of things happen. There are no automatic death penalties in the state of Florida. So listen to what I said. It is a possible penalty in this case. Because of that, we conduct jury selection in stages. You all are actually going to go through stage 1 and 2 today. And I'm going to be asking you a series of questions. At the end of that series of questions, we're going to send you out of the room. Some of you will be brought back in for individual questions. You're joining another group from this morning that's already gone through this process. Before I do that, I need to instruct you on a couple of things. This is your first jury instruction, and this is a court order. You are not to, from this point until you are discharged as a juror in this case, released from service, you are not to look up anything about this case, talk to anyone about this case, and that includes each other. Jurors may not speak to one another about cases. You are not to look up anything on your phones, the internet, YouTube, Facebook, nothing. You're in a cone of silence about this case until I discharge you as a juror. The reason for that is very simple. Our criminal justice system guarantees fairness to both sides, and it is fundamentally unfair to both sides if jurors are in a jury room discussing a case and reaching a verdict on information that no one has any idea that they have or that they're using, and which may be completely inaccurate or completely inadmissible under Florida law. A juror's job is to sit in that jury box and listen to the evidence that comes forth in the courtroom, and you can base your verdict only on that evidence. And like I said, it's fundamental fairness. Both sides get to know what the evidence is. They get a chance to flush it out, discuss it, challenge it, present contrary evidence if they feel there's that, and everyone knows what information the jury is relying upon to reach its verdict. Do not violate this order, because I will sanction any juror who violates that order. So I'm going to start by asking you all some basic questions, and you need this information to answer these questions. This case, as I told you, the jury is going to be sequestered, right? It is a death penalty case, so we're going to sequester the jury. And what that means is you're going to be, once you're picked as a juror, you're going to be taken to a hotel. It's a very nice hotel. Each one of you gets your own room. You can bring your electronics. However, the deputies have custody of them, and when you use them, you will be in a room where the deputies can see and hear what's happening to make sure that no one is discussing the case. Not only you, but friends and family that you may be talking to. You would be amazed how often people want to give jurors their opinion about cases jurors are sitting on, an opinion you are not allowed to hear. You can do work, you can do schoolwork, you can Zoom call or FaceTime with friends and family. We do make arrangements for you to see close family, your spouse, your partner, your children, during the time you're sequestered. You can watch television, but you can't watch the news. You can't read the newspaper. We do have a ban on that. There are activities at the hotel when you're not in the courtroom. We work, the case is going to take 2 to 3 weeks. We work from 9:30 to 5:30 on Fridays. And we work from 9 to 1 on Saturdays. Because it's a sequestered jury, we need to move this along. You do get 3 meals a day provided by the state of Florida and the hotel. Someone's going to cook and clean for you. Someone's going to make your bed, clean your room. So there are some advantages to being sequestered, in that some of these tasks that you have to perform yourself, you do not have to perform. All right? So having told you all of that, let me start with, I'm going to do this by rows just to Make it easy. For jurors 1 through 6, is there anyone in that group whose employer does not pay them for being on jury duty? All right, juror in seat number 1, do you get paid, ma'am? You do get paid? All right. Thank you. Juror in seat number 3, do you get paid? And can you pay your bills if you're not being paid for 3 weeks? You can? Okay. Who else raised their paddle? Someone else did. Juror in seat number 6. Yes, ma'am. Do you get paid? And can you pay your bills?
How much time I have to work?
What kind of work do you do?
I work in social media and I run communities or to apps and websites.
And how many hours a day do you need to work in order to keep your income up?
Maybe 4 or 5.
So that would mean if you left here at 5:30, you'd have to work until between,
9 or 10 probably.
including eating dinner? Oh, okay. All right. So if you weren't able to keep that up, would it affect your income? And would you be able to pay your bills? All right, thank you, ma'am. I'm also trying to keep notes while I'm asking questions, so bear with me. Jurors in seats 7 through 12, anyone whose employer does not pay them for being on jury duty. All right, juror in seat number 9, yes, or seat number 8, yes, ma'am. Do you get paid? You do? Okay. Juror in seat number 9, do you get paid? And can you pay your bills if you don't get paid? You can? Okay. And someone else raised it. Juror seat 11, yes, sir. Do you get paid? Okay. All right. Jurors in seats 1 through 6, anyone who has a child care issue that cannot be resolved if you were sequestered for 2 to 3 weeks. I don't see anything. 7 through 12, none. Anyone who has the care of an adult, whether it's a parent, anyone who's dependent on you. I don't see any paddles. Anyone who has a vacation that has already been paid for. All right, juror in seat number 2, when's your vacation? And I'm talking October, November. Yes, ma'am.
November 7th to the 11th.
Okay, where are you going?
I don't know yet, surprise for my birthday.
Well, that's fun. And 6, yes, ma'am.
The first weekend of November, I take my mom on her 70th birthday.
Okay, where are you taking her?
To Atlanta to be able to see her nephew. I mean, her.
Okay. Anybody else in that room? 7 through 12, anybody who's got a vacation that's already been paid for? Anyone who has trouble with the English language? Anyone who has medical issues? Yes, ma'am. All right. COVID? All right. Thank you. Yes, juror in seat number 7. Yes, sir. Okay. Sir, do you think that that would interfere with your ability to serve as a juror? No, everything is ADA compliant. The courtrooms are, the jury boxes are, there's ramps instead of stairs. Are you, anything else that we would need to accommodate? No? Okay. And you'd be okay sequestered? All right. Anybody who's got any medical appointments, anything like that, that can't be changed? Juror in seat number 1, yes, ma'am? Are you a single parent?
Yes.
Okay. Is there someone else who can take them? Okay. Who can take care of them while you're in jury duty? Okay. Anybody else? Right. I sympathize, and believe me, I understand about work piling up on your desk when you're sitting in a trial. Unfortunately, it's not a legal reason for me to excuse folks from jury duty. So my question is this, not regular work, but do any of you have any special projects or projects or work that you're the only one who can do it, and it being a juror would interfere with it? And 6, you've already told me about your issues. Anybody else? Juror in seat number 8. Yes, ma'am. Yes, ma'am. Yeah, after we're done, there's arrangements made for everyone who needs to work or students, anything like that, okay? So you'd be good? Anybody else? Yes, sir, juror in seat number 7. Okay, so let me ask you this. Can you do that, the IT job, could you do that after you're done with court? Okay. Anyone who anyone else who has that type of situation, promotion, new job, that kind of thing? No? All right, anyone who has an issue that I haven't thought of and haven't asked you about? Nope. All right. I did forget to tell you all that we're aware of how uncomfortable those masks are. We did not deliberately pick the world's most uncomfortable mask. We need to be able to see your faces during jury selection. Once we're done with jury selection, you can wear your regular mask if you're seated on the jury, so you won't have to wear those forever. Is there anyone on the panel besides juror in seat number 6 who has any sort of autoimmune issues or heightened vulnerability to COVID? No? Okay. I'm going to send you guys back out. We'll bring you back in just a minute. You're going to be joining, as I said, the other group of jurors, except for the juror in seat number 12. If you'd stay in the courtroom, sir, for one moment. The rest of you, just follow the deputies. Meet your fellow prospective jurors. Leave the paddles, yeah. Thanks. I needed the juror in seat 12. That's you. I'm sorry. That is, you moved. I haven't memorized anyone's face yet. I'm just going by where people are seated. Good morning. You indicated that you'd heard something about this case. Is that correct?
Yeah, so it's something else like all over the news, but first of all, I really do too much digging into the fact that it's just what was publicized.
Okay.
With that,
How much of it did you watch?
really not much, but enough kind of, like doubt.
To have doubt? Okay. So did you you said you'd formed an opinion as to whether or not Mr. Loyd was guilty. Is that correct? And what is that opinion?
It was
Okay. So In order to sit in any criminal case, jurors have to be able to presume the defendant to be innocent until and if the state can prove he's guilty. Would you begin the trial presuming him to be guilty?
I believe I'm a reasonable person, as long as I have all, the evidence.
Okay.
For me, that I can, formally get an opinion, but, that's where I'm at right now.
All right, so let me ask you a question. I'm going to give you 3 scenarios. You tell me if any of these apply to you. If they don't, just say so, okay? Scenario number 1, and by the way, in all 3, it's the first day of the trial. You haven't heard anything. You're just sitting over here in these comfortable chairs, not those benches, waiting for us to start, waiting for witnesses to start taking the stand. And you're sitting there thinking to yourself, I think this gentleman is innocent and the state needs to prove to me that he's guilty beyond a reasonable doubt. Scenario number 2, you're sitting there thinking, I think this gentleman is probably guilty, but I'm willing to hear it out and see if I'm wrong. And scenario number 3, you're sitting there thinking, I think he's guilty, but if he can convince me otherwise, I'm willing to listen. Do any of those 3 apply to you? Which one? Number 3? Okay. Number 2, I'm sorry. Okay. State. Defense.
No objection.
All right, thank you, sir. You are free to go. All right, thanks. What is this? Oh, okay. Sure, I'll just keep adding to the piles. All right. On this panel, I have, let's see, juror in seat number 1, I don't see any issues, so I'm sending her back through. Juror in seat number 2 is a vacation, 7th through the 11th. Any objections? State? Defense? All right. Juror in seat number 3 can pay his bills. We're going to have to bring him in and ask him about that Pritchard family connection. So 4, 5 are coming through. 6 can't pay her bills unless she works 4 to 5 hours after hours. State? Oh, the vacation. Yeah, that's right.
We agree.
All right. Granted, 6 is struck. 7 is the gentleman who's got the IT promotion coming up. I can bring him back or excuse him. State?
We agree.
All right, I'll strike him. 8, 9, 10, 11 are all coming through, and 12 has been struck. So smash these 2 panels together and bring them back in. So I'm gonna do the individual voir dire instructions now. Okay. Good? All right. Okay, welcome back, folks. This is phase 2 of jury selection this morning. Again, we're going to try and get you through here as quickly as possible, but recognize the seriousness of the case. It's going to take us a few minutes with each one of you. So I'm going to give you some further instructions, and I'm going to give you some further information about the case. Yes, ma'am? Nope, they were sworn once this morning. So before I do that, now that we have 2 separate groups together, do any of you all know each other? No? Okay. All right. Let me start by giving you some more information about the case. As I told you, this is a capital case, meaning the death penalty is a possible sentence in this case if and only if there is a conviction for first-degree murder. So I'm going to start by telling you what Mr. Loyd is charged with. Then I'm going to give you some instructions, and as we go along, I will be giving you more information. That information will be necessary for you to have in order to answer the questions that we're going to be asking you individually. So, Mr. Loyd is charged by indictment. I have a copy of the indictment right here. Indictments are, it's paper. It's the way we tell people in the state of Florida what we're charging them with or what they're being accused of doing. You have to tell people what you're accusing them of doing. This is how Florida does it. Indictments are not evidence of guilt, and jurors may not consider an indictment to be evidence of guilt. The other way of putting that is, just because someone's been charged with a crime does not mean they're guilty of it, and you may not assume they are just because they've been charged. In fact, in all criminal cases, jurors must be able to presume the defendant is innocent until and if the state can prove they're guilty beyond a reasonable doubt. In this case, Mr. Loyd is charged with first-degree murder with a firearm of a law enforcement officer. Count 2, attempted first-degree murder with a firearm of a law enforcement officer. Count 3, aggravated assault with a deadly weapon. Count 4, carjacking with a firearm. And count 5, possession of a firearm by a convicted felon. It is the first count, first-degree murder of a law enforcement officer, that if he is convicted of that, makes death a possible sentence in this case. I'll get into more detail about what I just said about it being a possible sentence in just a minute. These cases are tried in 2 phases. The first phase is known as the guilt phase. That is the phase during which a jury must determine whether or not he is guilty of the charges he is facing. The guilt phase in a capital case is conducted the same way as we do all other criminal cases. You're going to be asked to return a verdict of guilty or not guilty on all counts, and your verdict must be unanimous on all of the counts, meaning each juror must agree on each count whether to acquit or convict. The burden of proof for the state in a capital case is the same as in every other criminal case. It is beyond a reasonable doubt. And the instruction you will be read on reasonable doubt is exactly the same as in all other criminal cases. The burden on the state is not higher because of the penalty. Your job as a juror in the guilt phase of a case is to sit in the jury box. The jury boxes are different in each courtroom, but this is the jury box in this one. You would sit in that jury box. Witnesses would be called to testify. Witnesses sit in the witness box. They're sworn in. The attorneys have the right to examine and cross-examine them, which is a fancy way of saying the lawyers get to ask them questions. Physical evidence may be introduced, such as videotapes, photographs, documents. All of those things may be introduced into evidence. Jurors must be able to see, hear, and understand what's being said, what's being read. If it's a document, you have to be able to read it. At the end of all of the evidence, I give you the jury instructions. The jury instructions are the law that you are required to follow in the case. It's not optional. You are required to follow the law. You decide what the facts are. You apply the facts to the law, and then you reach a verdict. And as I said, the verdict in this case Each juror has to agree to either convict or acquit on the counts. So when you're deciding guilt in this phase of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including first-degree murder, on their own merits. And you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you, of course, as jurors, to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. Now, if and only if the jury returns a verdict of murder in the first degree, you will then reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. That's what's known as the penalty phase. That is phase 2 of these cases. If that happens, a special set of rules and instructions come into play. I'm not going to read those to you now. I'm just going to give you a broad outline that hopefully is sufficient for you to be able to answer the questions we're going to be asking. To reach a penalty phase in a case, the jury must have found the defendant is guilty of first-degree murder beyond a reasonable doubt. You're convinced of it. It's beyond a reasonable doubt. First-degree murder means premeditated killing of another person, intentionally killing another human being when you have no legal justification for doing so. The types of things that are legal justification would be like self-defense. There's no defense to the charge. The jury's heard everything and determined that they're guilty of first-degree murder. The death penalty in Florida is reserved for one class of crimes only, and that is murder in the first degree. So the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The circumstances that I'm talking about created by the legislature are these. The prosecution relies on what are known as aggravators. Aggravators are statutory. There are 16 of them. In order for death to be a possible sentence in a first-degree murder case, the state, these gentlemen over here, must prove at least one aggravating factor, one aggravator, beyond and to the exclusion of every reasonable doubt. If they do not prove that, then the only possible sentence is life without the possibility of parole. If the state proves one or more aggravators beyond a reasonable doubt, then the entire process of the penalty phase would occur, which is the defense has, the things that the defense relies upon are called mitigators or mitigating circumstances. They do not have to be proven beyond a reasonable doubt. They only need be proved by the greater weight of the evidence. It's a lesser standard than what the aggravators have to be proven. The mitigating circumstances are not limited by statute, and they may include matters that are relevant to the defendant's background or character or the circumstances surrounding the offense. Mitigating circumstances are offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. Life in prison without the possibility of parole in Florida means exactly that. The defendant will die in prison. We do not have parole in this state. So mitigators are the reasons based on the defendant's character, his background, the circumstances of the offense, anything that relates to things like that, that the defense presents to you as a reason to vote for a sentence of life without the possibility of parole after someone has been convicted of first-degree murder. Aggravators are the reasons the state presents to you why they believe that the appropriate sentence is death. All of this occurs during a penalty phase. The penalty phase is another trial. The state presents evidence, the defense presents evidence. At the end of that, I give you the jury instructions and you retire to the jury room. You must keep an open mind throughout the penalty phase, from the beginning until the end of it. And you have to be able to fairly and openly process the evidence that's being offered to you and consider it. All right, I'm going to get into more detail about this. At the end of the penalty phase, I'll give you the jury instructions, what the law is on this. But you're going to retire to the jury room with your fellow jurors. Y'all can talk about it among yourselves, but it's an individual vote in the penalty phase. And you're required to weigh aggravators and mitigators. What I mean by that is not that you're going to go in there and add up the number of aggravators, add up the number of mitigators and say, oh, this side has more, they win. That's not how it's done. Weighing aggravators and mitigators means that you've listened to all this evidence that's been presented to you by both the state and the defense. You've listened to it with an open mind. You've processed it. Now you need to decide what's important to you in making your decision and what isn't. And that's different for each individual juror, right? So one of you may think this aggravator is critical to me making a decision. The other person may say, not that one, but this one is. Or same thing with the mitigators. You may think, this one really matters to me. This is important. I give this great weight. There are others you may say, this really, I don't believe this is important to me. Jurors can reject any aggravator or mitigator they choose, but in the end, you have to weigh them individually. All 12 jurors, it has to be unanimous. All 12 jurors must unanimously agree that at least one aggravator has been proven beyond a reasonable doubt, and all 12 jurors must unanimously agree that death is the appropriate sentence before a court may impose a sentence of death. All right? A life sentence without the possibility of parole does not require unanimity. The final step in the penalty phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, it's unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your findings, of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. It's a broad outline of how the penalty phase portion of this goes. I want to caution you all that the fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether the death penalty, this is a case that justifies a death penalty. I don't know that and you don't know that. I'm only discussing this because it's a possibility and we need to know, and you need to know, if you're able to do your job as a juror in this case. And your job as a juror is to follow the laws of the state of Florida and to keep an open mind and be willing to weigh both sentences and consider them before rendering a verdict on this. There are no automatic death penalties in the state of Florida for any type of case. We are going to be asking you some questions about the death penalty. I'm going to tell you what some of them are so that you can think about it while you're waiting to be called in. We're going to ask you about your feelings about the death penalty, your position on it, whether you're someone who could go through the process I just described with an open mind, or whether the mere fact that you've convicted someone of first-degree murder would result in one sentence or the other automatically without really being able to consider aggravators and mitigators. We're going to ask you if you've got any sort of religious or personal convictions about this. Many people have very strong feelings about the death penalty. It does not disqualify you from being a juror so long as you can put those feelings aside and follow the law as I instruct you. All right, I'm going to switch gears a little bit and talk to you about the insanity defense. In this case, the defense has raised the defense of insanity. This would be during the guilt phase of the proceedings when you're trying to decide whether or not he's guilty of the charges against him. This is the one time that the burden to prove it is on the defense, not the state. The defense has to raise insanity and prove it by clear and convincing evidence. It's a lower standard than beyond a reasonable doubt. There is an instruction that is given to jurors at the end of a guilt phase on the insanity defense, but I'm going to read you the definition of insanity so that you can have that when we're asking you questions. A person is considered to be insane when he had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. You are going to be asked questions about your feelings about this type of a defense, and if it was proven to you, would you be able to accept it? Lastly, I'm going to read you a statement of the case. On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That last portion I just read to you about Ms. Dixon and her unborn child, she was pregnant at the time, cannot be used by you to determine whether or not Mr. Loyd is guilty of these charges. They're two separate cases. It can only be used in the penalty phase, and I'll give you further instructions on that. So we're going to be asking you questions about whether you can follow that instruction I just gave you and put this out of your minds during the guilt phase. All right, I'm going to confirm this just to make sure, because I've had several, had quite a few jurors in and out of here today. Anyone who's heard about this case, please raise your paddles. So I have 7, 10, 23, and then 3, 4, hold on, 5, and 8 from the second group. So from the first group, raise your paddles again if you've heard about this case. 7, 10, 20, you've heard about it also? Okay. All right. Thank you, folks. So here's what I'm going to do. We're going to start the individual questioning. At some point, I'm going to release some of you to go to lunch, and then instructing you when to come back, because I can't get through this whole group before lunch, and we don't want you to starve to death while we're doing this. If you're at lunch, do not talk about this case. Do not look up anything about this case, and talking about it includes amongst each other. If you happen to run into any of the attorneys, they are not going to speak to you. They're not even going to say hello to you in the hallways. They're not allowed to. They're under court order not to have any contact with you outside the courtroom. Please don't hold that against them. They're not being rude. That's just the instructions they've been given. All right, if you all will follow the directions of the deputy, you're what number are you? 4? Juror number 4, if you'll stay in the courtroom. 4 from the first panel, stay in the courtroom. Everyone else follow the deputies, please. Leave your paddles. Take them with you? All right. Whatever the deputy just said. I'm willing to turn this over to anybody. All right, you're juror number 64, correct? All right. That's all right. Yes, ma'am, is fine. You've never heard about this case, is that correct?
Been through a lot of past year as I mentioned, so if I did, I just thought about it.
Okay, no worries. I'm just, like I said, I've had a lot of people in and out of here, so I have to confirm everyone's answer, make sure my notes are right. You're the gentleman who's having the custody battle. Okay. How long has this been going on? You don't have to give me the details, okay? Your personal life is your personal life, but how long has this been going on? How old is it your son or your daughter? Okay. So my question for you is, if you were chosen as a juror in this case, will you be able to concentrate and pay attention? Or are you going to be thinking about your custody battle?
I think I'd be able to, yeah. I've got really good attorneys, and they've been doing it pro bono, you know, so. So, yeah.
Okay. And so these conferences you have to have with your attorneys, do you believe that that is something that you could do after hours when you weren't here in the courtroom? Because, I mean, you can talk to them by Zoom. That's not a problem.
Yeah, I've got a, I'm not the David to attend and stuff, but yeah, everything else, new job, so. I think I'll be okay.
Okay. And you said you got a new job, but you get paid for being in jury duty.
Oh, yeah, he told me, yeah,
Okay.
salary.
That's a good employer. I wish more were like that.
Can I tell that?
You can. You absolutely can. And you also know Todd Erb, but, okay. If Mr. Erb took the stand to testify, was your relationship such that you would just automatically believe anything he said? Or would you be able to weigh his testimony as direct? We give you instructions on how to weigh jurors' or witnesses' testimonies. And by the way, jurors can believe or disbelieve anyone they want to, but we ask you to treat all witnesses the same. Do you think you could do that, or would you have difficulty with it?
I'd be able to do that.
Okay. Do you have a position on the death penalty, sir?
No strong feeling either way.
Are you someone who has a religious, moral, or personal objection to the death penalty? Are you someone who believes that if someone is convicted of first-degree murder, intentionally killing another person, they should automatically be sentenced to death? You heard me describe what the procedure is. You have to keep an open mind through the penalty phase. You got to listen to the aggravators and the mitigators and then weigh those. Can you do that? Okay.
This is where I said I went to law school.
Oh, okay, you did go to law school?
Yes.
How far did you get? Did you graduate?
Yeah.
You did?
Yeah.
And then
But
you,
I said that before, you never asked anything else.
no. Have you ever practiced law?
No, the bar once, I started working at sales and sales.
Probably a wise choice. All right. So you understand the process of how this works, okay?
I graduated twice, so it's been 3 years.
You should still remember some of it, okay? So let me ask you a couple of questions. Number one, in this case, if there was a conviction for first-degree murder of a law enforcement officer, would that change your answer about automatic death penalty? And if I add to that there's a prior conviction for the murder of a pregnant woman, would that change your answer? Okay. Could you keep an open mind through the whole thing? And if you believed that the appropriate sentence, after weighing everything out, you believe the appropriate sentence was life without parole, could you vote for that?
Yes.
And could you vote for death if you thought that was the appropriate sentence?
Yes, Your Honor.
Is there anything about the insanity defense that makes you uncomfortable?
No, Your Honor.
And if it was proven to you, would you be able to vote not guilty by reason of insanity?
Can you repeat that?
If it was proven to you, if the defense met their burden and proved to you he was insane at the time of the offense, would you be able to return a verdict of not guilty by reason of insanity? And lastly, can you put the murder of Miss Dixon and her unborn child out of your mind when deciding whether he's guilty of these charges or not? All right, thank you, sir. I don't have any further questions, but I'm sure the state does. Mr. Buxman, you may inquire.
Good morning, sir. On your jury question there, you indicated that either you or a member of your family had been put in a lawsuit. Is that the custody issue you're referring to?
Yeah.
Okay. And I think you also indicated on your questionnaire that you were a close friend or was related to, or related to a law enforcement officer.
Yes, I'm a small town Florida where I grew up.
And how is a close friend of yours?
He was, I called John.
Okay. Knowing that this case involves the murder of a law enforcement officer, would that close friendship with that friend from South Florida affect your decision in this case in any way? When you decided to go to law school, did you have some kind of specific area of practice that you were interested in?
No, when I went to law school, I actually wanted to be a doctor more over anything.
Okay.
But no, I didn't have any, like, secure or anything. I didn't have no classes. Anything lined up or anything, so.
I'm going to start off with a couple questions about the insanity defense. Because the insanity defense obviously involves allegations of mental health issues, I have a couple personal questions for you. Have either you or a close friend or a family member ever experienced or had involvement with mental health issues? Has he been diagnosed with a specific mental health issue? I'm not going to ask you what it is.
You let him go, it was like after 2 days.
And he's doing okay right
Yeah,
now?
he's got 2 jobs.
So I'm assuming based on that personal experience, you do believe mental health issues are real for some people. And would you be able to listen to all the evidence as it relates to the insanity defense and consider all of that evidence to determine whether or not it's proven to be that a mental health issue exists in this case, and if so, what the consequences are? Yes.
Yeah.
Shifting over to your views on the death penalty. From your answers earlier, it sounds like you're kind of middle of the road as far as your opinions of the death penalty. Is that a yes?
Yeah, sorry.
That's okay, everyone does it. Would I be correct in assuming that your belief in some cases it's appropriate, in some cases it may not be?
That's correct, yeah.
And since you probably have a little more familiarity with the terms and the process that we're going through, I'm going to kind of push through these questions rather quickly. But can you understood the concept of the aggravators, right? And if those aggravators that you heard, evidence that makes this murder more egregious or worse than other murders, if those aggravators, as you're hearing them, start moving your decision-making pendulum more toward death as the appropriate punishment, no matter how far that goes over toward death, would you be able to still consider any and all mitigating evidence within the yes, regardless of what it is? Did you consider it, even if at first blush, when it's first brought to you, you're thinking, I don't know if that's really mitigating. Could you hold off judgment until you hear the actual details and the evidence that surrounds that piece of evidence? Would you be able to do that regardless of what piece of mitigating evidence? That's all I have, Your Honor. Thank you, sir.
Mr. Buxman. Mr. Lenneman, you may inquire.
Thank you. Good morning, sir. How are you? So I'm a little curious about how yesterday you seem to be really pushing not to serve on the jury because of all the difficulties No, you were here yesterday.
I was not here.
When you were here last,
Earlier.
earlier.
Yeah, it was something I was mentioned to the
It seemed that at that point, you were pretty committed to not wanting to be here.
I never did that out loud when I was, it was just like I said, it was asked me to bring a painting, and then so I figured it would be worth bringing up. Yeah, so, and the judge let me know that, I don't know about so that's why I brought it up, but and maybe if I could find something, hopefully it'll be,
You answer it?
sure, yeah.
From 1 to 10 being death penalty, and 1 being not.
Nobody that the job is mentioned, so, I'll be like,
You said the death penalty law. How often have you guys discussed this work?
every so often, I mean, we made it on some, viral video, yeah. So, talking, but we laughed about that, talking on the highway, like, and the people covered, so we laughed about that, but not too long.
You actually do discuss this work. Okay. And I know the judge asked you, you're not going to allow it to affect your opinion of law. Why?
But I studied for 3 years, I was taught that disabled side, but if I could do that for 3 years to graduate, I could do that for, that's for,
So you're saying you were taught to do this in law school?
I was taught in a track, these schools, you get a state, it's a track, and disabled side, disabled side. That's what I feel like in the setting I can,
So you were trained to be a good juror?
I mean, essentially, I don't know.
What about your personal feelings? Set aside the training you received about being fair. What about your personal feelings, your relationship with someone who is in law enforcement, and the fact that this is the case that the law is doing?
Yeah, I can put that aside.
But what are your personal feelings?
My personal feeling is that, when you're called on to do this duty, you have to put everything aside for it, and therefore, I know that.
That wasn't my question. I want you to listen to my question. I want you to put aside all that training and being even-handed. I want to know what your personal feelings are about the fact that you have your best friend or one of your best friends, law enforcement officer, in this case involved with law enforcement. What are your personal feelings?
My personal feelings are that, fortunate that, that law enforcement passed, obviously, and but I can't, I will not let that, my ability to feel,
And how did you know Todd Hurd?
we were both working together,
And how long did you work with him?
couple years,
Look at him. And when was this?
late 2018 to late 2020 when I got laid off.
Okay, did you guys work together?
Yes.
Okay. Did you have a relationship with him? Did you talk about And would you be concerned that because of your relationship, and he knows you're on the jury, you find out, you came to the conclusion that was basically saying that you wasn't being honest?
No, I don't think it was. I don't know. For me, no, I don't feel like it's.
So you don't have a problem with telling the phone? What do you feel is All right, I want to talk a little bit about the death penalty. You heard that when the death penalty was so I want to ask you, first of all, you believe racism? Would you be able to consider as a mitigating factor the effect of racism on our crime?
Yes.
And you mentioned that you had a brother that was who's going to be there.
Yes.
He taking medication.
I'm not aware of one of them that looked like it. Not at all.
You would consider mental illness and mental health issues as a mitigating factor. Now, the judge talked to you about this concept, not only rejection law, but there are certain things that some people feel that the death penalty stands for and should be automatic. Is that reasonable? Now, one of the situations in this particular case is that the judge told you you cannot use the fact that Mr. Loyd was convicted of killing Ms. Dixon who was pregnant during the first trial. And you said you would. Okay. So now, in the second part of the case, that's going to be considered an aggravated factor. And you get to decide the question is, the fact that you become part of the penalty phase and you are told by the prosecutor about this potential aggravating factor in fixing you pregnant, are you going to automatically think to yourself that, that he why not? And the last couple of questions I want to talk to you about is the actual process. If you're a juror, there's only one thing you can decide. That's whether aggravating factor. It requires for you to go to the next step of your responsibility that in fact, all 12 jurors don't aggravate it. Okay? Understand? So the second and third part is fourth part, fifth part, and then break it down, is all about what you yourself. So you yourself would look at the aggravating factors and determine whether they were proven beyond a reasonable doubt. And you yourself would determine what weight to give it. And then on the other side, mitigating factors, you yourself would have to determine whether there was a proven and the lesser standard than the lowest. And if they're proven to you, you get to decide what weight you want to give those. Yes. And then at the end of that, you get to weigh the aggravating factors and mitigating. If the mitigating factors are outweighing the aggravating factors, then that's life. so then the next step is you all tally your votes. And we can talk about this, and you can handle this as a personal decision. You can change anyone, it's up to you. Okay? You tally your votes. If there's not 12 jurors that vote for death, then there's not a death vote. It's all 12. Understand? There's one juror that votes for life, whether it's you or someone else, it's a life verdict. Understand that? And you see how you can make a big difference. And the final thing is, it seems that you're pretty fair-minded, and you're not the kind of guy who's going to try to push your opinion on someone else. Is that fair to say? So you would agree with me that you respect other people's opinions no matter what they are. And in terms of your opinion, if you have a concrete belief, whatever the opinion is, like the death, you're going to stick to that concrete belief. Once you reach a decision that you are sure of, after you decide and go through everything, and talk to people, whatever it is, whatever decision you make, you're going to be able to stay with that decision and not let somebody change your mind.
Yeah.
Okay. Thank you. Oh. Now, you were working, how long did you work at that company? Okay. And Todd Bird was working there till when? Okay. So he was working there in...
I think he got there after I got there. I can't remember exactly when he got there. I started working more closely with him in late 2019, early 2020.
Okay. So you were working with him in October, November, did he ever talk to you about his testimony in the trial?
He didn't tell me that.
Did you know that he was testifying?
No idea.
You never talked about his shooting?
No.
You know he knew you were a lawyer?
No. Yeah. I'm not even sure if he did. I don't even know if he testified.
All right, thank you.
Either side need to approach.
Yes.
Come on up. All right, sir, we're going to send you through to the final round of questioning. It is Monday morning at 9 o'clock. It's going to be in court. You're going to need to report to the jury room. If you'll hand the deputy your badge. Yeah, you'll need to come, have a seat. I'm not done. You're going to need to return on Monday morning. Report to the jury room. We're going to start jury selection at 9 a.m., okay?
Here. 7:30 again?
I don't think you need to get here that early, because you don't need to listen to the film and all that again, but be here before 9, okay? You're now a purple dot, because we call jurors in by colors, because the groups are so large. So just call after 5 today to confirm that we're still on for Monday morning at 9. You're just going to hear a recording. We've given you a package that explains, well, A, that gives you the phone number to call. B, it gives you an explanation of sequestration and being sequestered and what to expect and what to pack. We are picking and sequestering the jury on Monday, so you'll need to bring a suitcase with you. Leave it in your car. If you get picked, we'll go get it. If not, don't worry about it. Excuse me. And lastly, we have a letter for your employer to let them know that you've been chosen for the next round. Do you have any questions?
No, you covered them. Thank you, Your Honor.
All right, thank you. You have a good weekend. We'll see you Monday. 6, Juror 138, seat 6. Seven. I'm just going in order. Yeah, I'm just going in order. Let me take the mystery out for you. I'm going in order. When I get 4 more jurors, we're done. Okay. 4 more jurors for general, I mean. I've sent the second panel to lunch because we are going to stop for lunch at some point. All right, welcome back. We have a few questions for you. There are no right or wrong answers to the questions that you're being asked. I'm going to start, and then the lawyers will ask you questions. I'm so used to wearing this, I forget I have it on, sorry. The reason you're being asked these questions is for all of us, including you, to determine whether or not you can do your job as a juror in this type of case. So the only correct answer to any question is the truth, okay? Let me start by confirming you've never heard anything about the case prior to coming here. All right. Do you have any personal, religious, or moral beliefs or moral objections to the death penalty?
Most of the time I do not speak, and it's not because of religion or
Okay. All right, so based on that answer, let me ask you a couple of questions. In this case, the charge is first-degree murder of a law enforcement officer. Would you ever consider, openly and fairly consider, a death penalty for that charge? Okay. Just to confirm, you heard me describe the process. You listened to the aggravators, you listened to the mitigators, you're back in the jury room, you're weighing all of this. Is there any circumstance that you can envision? You went back there, you thought the aggravators outweighed the mitigators, you thought death was the appropriate sentence. Would you be able to vote for death, or would you automatically vote for life in prison? All right, thank you, sir. State. And thank you, sir. You are free to go. So next up is 7, Juror 128. All right, welcome back. How are you? This really isn't going to be as painful as you think, all right? We're just going to be asking you some questions. I'm going to start, then the lawyers will have some questions for you. There are no right or wrong answers to these questions, and the point of the questions is to determine whether or not you can do your job as a juror in this type of case. You need to know that, we need to know that. So the only correct answer to a question is the truth, okay? You indicated that you knew about this case, is that correct? Okay, can you tell me what you remember hearing on the news? Just relax, I don't know what you saw, so that's why. That's the only part that you saw? All right, did you read anything about the case? Did you talk to anybody, like family, friends, coworkers? No? All right, based on what you saw, did you form any opinion as to whether or not Mr. Loyd is guilty? Jurors must be able to presume him innocent until and if the state can prove he's guilty. Can you do that? So let me talk to you a little bit about the death penalty. Do you have any moral, religious, or personal objections to the death penalty? So you don't believe in the death penalty? All right. How long, and you said you grew up, so has this been your entire life that you've had this belief? Okay. So, ma'am, as a result of that belief, would you ever consider voting for a death penalty in a case? Or, so you would always vote for life? Is that a yes? Okay, no problem. All right, state? Defense? All right, thank you, ma'am. You are free to go. Thanks. Juror in seat 8, juror number 91. Good afternoon. How are you? I'm well, thank you. We're just going to be asking you some questions. I'm going to start and then the lawyers. There aren't any right or wrong answers to these questions. And the point of the questions is to try and determine whether or not you can do your job as a juror in this type of case. That's something that you need to know, that we need to know. So the only correct answer to a question is the truth. You have not indicated that you've heard anything about this case. Is that correct? You just don't remember? Okay. Do you have any personal, moral, or religious objections to the death penalty? Are you someone who believes that if a person is convicted of first-degree murder, intentionally killing another person with no legal justification for it, that that person should be sentenced to death? Okay, so for you, is it an automatic, it's first-degree murder, I'm voting death, or is it, I need to see what happened before I can vote? Okay. Let me explain again that in order to be in a penalty phase, someone has already been convicted of first-degree murder. Guilt is over. The jury's voted guilty beyond a reasonable doubt. Now there's aggravators, reasons that The state is arguing death should be the appropriate sentence. And mitigators going to a defendant's background, their character, maybe the circumstances of the case, some additional information that may not have come out during the guilt phase, or some information that did come out during the guilt phase, but it's now a focus on the defendant and whether that person should be sentenced to death. So mitigation goes to a basis for a sentence of life in prison without the possibility of parole. You with me so far? If you convicted someone of the first-degree murder of a law enforcement officer, would you automatically vote for death without listening to anything? All right. And if I added to that that they have a prior conviction for the murder of a pregnant woman, would your answer change? Okay. So it would influence you, but not automatic. All right. So you're in a penalty phase. Your job is to listen with an open mind, not, you know, I'm waiting to get to the end of this so I can vote. It's, I'm listening, I'm processing this information all the way to the end, all the evidence by the state, all the evidence by the defense. Then you're going to go in the jury room and weigh that all out. Do you think you could do that with an open mind? And if that process led you to believe that life without parole was the appropriate sentence, could you vote for that? And if it led you to believe that death was the appropriate sentence, could you vote for that? Any doubt in your mind about that? Second question, the insanity defense. I told you Mr. Lloyd's raised it in this case. It's the defense's burden to prove it by clear and convincing evidence, lower standard than the state has to meet. It's the end of the guilt, pretend it's the end of the guilt phase. You've heard all the state's evidence, you've heard all the defense evidence. You think he was insane at the time of the offense. Could you vote not guilty by reason of insanity? And then lastly, the murder of Miss Dixon and her unborn child, you can't use that to determine whether or not he's guilty of these charges. You have to put that out of your mind. Can you do that? Do you have any doubt about that? All right, thank you, ma'am. I have no further questions for you. The state, however, does. Mr. Buxman, you may inquire.
Good afternoon. Pretty good. How you doing? I'm going to start with a couple questions about the insanity. Is that something that's going to be addressed in the first part of the trial? Guilt phase? There are a couple personal questions because of the nature of qualified case. But do you or close friends or family members have any experience involved? I'm not looking for names. You need to have any relationship. Okay. Are those family members going through treatment, medication, things like that? Nothing? Were you around those family members while they were going through these process? Based on your personal experience, I would assume that you do believe that mental health issues are real to society. Would you be able to listen to all the evidence about, in this case, about whether there is a mental health issue involved in this case? If there is, what the effect of that issue would be before you make a decision as far as whether insanity would be included. Shifting gears a little bit to the penalty phase, the second phase. For purposes of these questions, I'm going to ask you to assume that the jury has listened to all the evidence in the first part of the trial, found the defendant guilty beyond a reasonable doubt, rejected any of the defenses, including insanity. And now we're here to determine what the proper punishment is, life or death. Right? These questions are kind of designed to focus on your ability to keep an open mind about all of the evidence you may hear in that case. Okay? As the judge indicated, and she went through a long explanation and it's thorough, so I'm not going to go into each step of the process again, but she indicated that the state will present evidence of aggravating factors that make this more than more egregious. These are the notable factors that they want that can be considered by you as prudent to determine if that makes this sentence the proper sentence in this case. Another one of those aggravating factors is prior conviction. That can be used in the guilt part of it, but it can be used if proven in the second part. So my question for you is, even though hearing those aggravating factors and any other aggravating factors you may hear, that may start causing your pendulum decision-making to swing maybe towards the death penalty. No matter how far it gets towards the death penalty, can you promise me that you will be able to consider and listen to the evidence of the mitigating circumstances, regardless of what those mitigating circumstances may be? Yes. And this isn't the time to talk about the facts and details and evidence surrounding each of those aggravating factors and mitigating. That's for the trial. But regardless of what type of mitigation is presented to you, are you able to listen to it, process the evidence that relates to each of those factors, and only after you've done that, then make it as far as the proper punishment? Would you be able to do that even if at first blush, when you hear a mitigating factor, you might think, I don't know if that's mitigating. Can you hold off judgment until you hear the details? Once you hear all of the evidence of the aggravating mitigating circumstances, then your job is to assign, number one, seal it and prove it. And if those factors have been proven, assign the weight. It's up to you how to do it. If, after hearing all the evidence and weighing it and mulling it over, you felt that, in this case, life imprisonment is a proper punishment, would you do it? And knowing that you never are legally required to vote for death. If you hear all the evidence and you weigh it over and you mull it over in your mind, and you think the proper punishment in this case is death penalty, you should be able to come back and raise your hand and vote death. Anything in your background, your life, your belief system that may make you not I don't know if there is, I'm just asking. All right. Thank you so much for your time, ma'am.
Thank you, Mr. Buxton. Mr. Lenneman, you may call.
Yes, thank you. So have you given the death penalty any thought before you came into this environment? What are some of the things that you have And those crimes that you think are really bad, would that deter you away from following the rules, or you would automatically do it? And what kind of things are important to you to look at in regards to
Sustain.
would you consider, you think that, would you really consider it mitigating that, the effect of racism on Michigan? You have no problem with it. Obviously, mental health and so, running through real quick how it works. I don't think there's anything happening. And the shift from your responsibility to the first part of the conviction now looks different than your responsibility. You are actually told from what you are told that this is an individual decision. you understand. So the only thing that you would do as a group, as a jury, at the time, is that you have to find some aggravated factor. That's all. From that point on, it shifts to you individually. You get to decide what weight there is in the aggravated, when you are moving it out, whether you're mitigated, or proven to a lesser standard, and give them weight, and then to weigh the two. If mitigators outweigh the aggravators, you can give any weight you want to any mitigator, and it has to be lesser. If the aggravators outweigh the mitigators, it may be the death penalty, all right? But it's never required. The law says that for any reason you want, even if the aggravators outweigh the mitigators, you can still go to the fight. You understand? And so you understand that one juror can make the difference. Because a unanimous juror, all death penalty verdicts to become the death penalty. And one juror makes the decision that it's a life sentence. So, are you the type of person that once you have a conviction, you move on? You're not going to let anybody bully you or cheat you. Okay. And so you understand, so it's clear. You can talk about it as much as you want, or you don't have to talk. But remember, this is an individual decision. So if someone is overstepping your boundary, you feel they're overstepping your boundary, you're stepping on your individual decision as compared to something that may be discussable. You would maintain your belief in your individual decision. You would stick with it.
Either side need to approach?
Hold on 1 second. Okay.
All right. Ma'am, we're going to send you through to the final round of questioning. So we're going to give you a purple colored dot. Final round is Monday at 9 a.m. You'll need to report to the jury room before that. If you get there by 8:30, you should be fine, okay? Couple of things. Call tomorrow. No, today's Friday, right? Yeah. Call tonight after 5. I've lost track. Call tonight after 5 to confirm that it's Monday, but it's Monday at 9. Just call just in case something goes horribly wrong. You are going to need to have packed a suitcase and brought it with you, because if you're chosen as a juror, we're sequestering the jury that day. So go ahead and pack. Leave it in your car. You don't need to bring it in. If you get chosen, we'll make arrangements for you to get it, okay? This packet we're giving you has 3 things in it: a slip with the phone number to call to verify you're here on Monday, a jury sequestration package, which includes suggestions about what to pack. There are laundry services, so you don't need to pack 3 weeks worth of clothes, and a letter for your employer. Do you have any questions? All right, thank you so much. Have a good afternoon. You're free to go today. All right, we're going to do the following jurors, and then I'm going to, so before we go to lunch, we're going to do 10, 20, and 23. Everybody else, send them to lunch and tell them to come back by 1:30, please. And 23. Let me just fill in, who was that? That's your number 91 that just left, right? Okay. Good afternoon, sir. How are you?
Good, how are you?
I'm doing well, thank you. You're juror number 80, right?
Yes, ma'am.
Okay, we have a few questions for you. I'm going to start, then the lawyers may have some questions. There aren't any right or wrong answers to these questions. We're asking you the questions to determine whether or not you can do your job as a juror in this type of case. It's something we all need to know, including you. So the only correct answer to a question is the truth, okay? Let me start with, you indicated you had heard something about this case. Can you tell me what you've heard, please?
Just from the news media, not really.
Okay. Did you watch any of the coverage? Like, not glancing, but watch it?
Not.
Okay. How much do you think you saw? Yeah, or just, did you watch a little, a lot? Okay. Did you talk to friends or family or coworkers about it? Do you recall reading anything about it, including on the internet, Facebook, the newspaper, anywhere? Do you remember what you read?
Same thing.
Thank you. All right, sir, thank you. Based on what you saw or read, did you form any opinions about whether or not Mr. Loyd was guilty?
Yeah, it seemed like it was. That's same crime.
Okay.
It's more barrel.
All right, so let me give you 3 scenarios, and you tell me if any of these apply to you, okay? If they don't, just say so. You've been selected as a juror in the case. You're sitting over here in the jury box waiting for it to start. You haven't heard anything, no testimony, no nothing. And if you're sitting there in that box, are you thinking, number 1, I believe this gentleman is innocent and the state has to prove to me he's guilty beyond a reasonable doubt? Number 2, yeah, I think this guy is probably guilty, but I'm going to wait and see if the state can prove it. And number 3, I think he's guilty, but I'm willing to be convinced otherwise. Do any of those 3 apply to you? Okay. Do you have any position on the death penalty? All right. So do you have a religious objection to the death penalty?
Personal basis, yes.
So any objection you have, is it one that you could put aside and follow the law of the state of Florida? All right. You're never required to vote for death in any case. It's just not a requirement in the state of Florida. But you have to be able to fairly consider it and weigh it. And if you felt that the evidence, the law, your personal feelings led you to believe that death was an appropriate sentence, you have to be able to vote for it. Would you be able to vote for it if you thought it was an appropriate sentence? All right. Is there anything about the charge of first-degree murder of a law enforcement officer that would cause you to not listen to a penalty phase? I mean, you've convicted someone of first-degree murder of a law enforcement officer, intentionally killing that officer. would you listen with an open mind to the penalty phase in the case, the aggravators and the mitigators? And could you weigh both the aggravators and the mitigators? And if you believe the appropriate sentence was life, could you vote for that? If you believe the appropriate sentence was death, could you vote for that? If I added to that the fact that there was a prior conviction for the murder of a pregnant woman, would any of your answers change? All right. The insanity defense, you heard me say that Mr. Loyd has raised that defense. It's the defense's burden to prove it by clear and convincing evidence. Pretend you're at the end of the guilt phase. You've listened to both the state and the defense. All the evidence is in, and you believe he was insane at the time of the offense. Could you vote not guilty by reason of insanity? And lastly, the murder of Miss Dixon and her unborn child, that has nothing to do with whether he's guilty or not of these charges. Can you put that out of your mind when deciding guilt? All right, you can consider it during penalty, but not during guilt. Do you have any doubts about any of the answers you've given me? All right, thank you, sir. I'm going to let the attorneys inquire now. Mr. Buxman, you may proceed.
Good afternoon, sir. I noticed in your jury questionnaire, you answered that yes to the question of have you or a member of your immediate family been party to the lawsuit. Can you expand on that a little bit? That actually go through the court system?
It was,
Okay. Is there anything about that experience that leaves a bad taste in your mouth about the court system, judges, lawyers, anything like that? Does that affect your decision in any way in this case? Is what?
it was unfair.
I have a couple questions about the information the judge told you about the incident. That is something that's going to be addressed in the first. Have you, a close friend or family member, had any experience?
Drug addiction.
Was that a close friend or family member? How was that?
Excellent. Another school.
Have they gone through treatment for that issue? Some members of the community, they have a belief that mental health. Would you be able to listen to any evidence about any evidence that A was for mental health issues in this case? And if so, B, what the effect that would have? Can you listen to all that? For the purpose of lead questions, I'm going to ask you to assume that the jury has already found the defendant guilty of three murders. Beyond a reasonable doubt, the jury has rejected any defense as it stands. Any of the defense and found guilty. Now, the second part of the process of the process. When you were talking with the judge, you indicated your habit, and you have a little bit of a personal objection against that. That's fine. All right. At no time will you ever be required to vote for that. There's not going to be a situation where you're going to need to check those. I'll be 5 o'clock. how do you, walk me through that process? Make that clear separation. If we're in the penalty phase now, and you hear evidence of these aggravating factors that are presented by the state individual, and you've heard a little bit of information about how everything is one, there's an aggravating factor used to weigh in favor of the death. Another factor you've heard about is that that can't be used in the guilt phase. So, assuming that you listen to the aggravating factors, you feel that the fact that she's a law enforcement officer, proven that she's prior murder, that may start swinging your opinion and pendulum over to death penalty being possible. No matter how far that pendulum swings over in your mind towards death penalty, you pull off the consider the mitigating evidence provided. Mitigating evidence meaning evidence of the defendant's background, upbringing, experiences, things like that. So is there ever going to be a point where you've heard aggravators and you say, I'm done, I'm not listening to anything else? Can you promise me you can listen to those mitigating factors presented by the defense? Even if at first blush when you hear it, you may think that's really not true. When you pull off judgment and you hear the details surrounding it and the evidence surrounding it, and you determine you can do that regardless of what mitigating evidence is presented. If you find yourself after you've gone through all this evidence, weighed all the evidence, you felt that in this case, life in prison, would you go through it? Conversely, if you felt that the death penalty was the proper one, could you, I'm not talking about hypothetical situations, you personally, when yourself in that position, you felt the evidence supported the death penalty. Is there anything in your background or life experience with the police system that makes you think you may not be a good juror? I don't know if there is. Thank you for your time, sir. No other question?
Thank you, Mr. Buxman. Mr. Lenneman, you may inquire.
So let me tell you why I made a statement that says law is precedent. Let me tell you what concerns me is that because of your dedication to following the law, even though the system, you are going to overcompensate. Get that you're being someone who gets to make important decisions in the second part of this case, emotionally, morally, whatever way you want to make it, you're going to overcompensate to follow the law to get who you want. Do I have to be concerned about that? Exactly. And when looking at mitigation and even aggravation, it becomes a personal decision. It's not a group decision. It's a personal decision where you yourself Now, the second step in the evaluation could be that you feel that the aggravating factors are individual. In that case, the law says you may, not have to, not compel, not required, but you may go through that. You understand that? And that's a personal decision. And to help some people with that personal decision, maybe you, maybe somebody else, there is a provision in law that absolutely says you are never required to go through. We'll hear that in the jury instructions, when we get to the jury instruction, if we get to a second page. Understand that? And that's your option to use that if you want, for whatever reason, maybe personal, maybe moral, or maybe other, something you saw or heard, but you were never required to go through. Okay? Can you do that? Can you follow that law? Now, you said you'd serve in the military. What rank did you fly? Now, we had talked about it, and I think really answered you before, I just want to make sure I understand your views. There may be a number of things that pile up. We talked to the bill, and this was required victim, Dixon, a child, some other children involved, brother. So there may be a pile of things that kind of come together for you. Knowing that you know what the law is, and you are required to do certain things in process, but you're even prosecuted. Is there a circumstance in front of that piling on that will, you believe, you would automatically
Objection, Your Honor.
This day.
so you can follow the law. And you can do that with your law. Now, you talked about at the beginning of the question that you seem to avoid into the guilt. You know, obviously, I'm concerned about that. Yeah. And so, we talked a little bit about why he seems to be guilty or not. But if you were to put a percentage on it, at the time, 15%, 20%, 80%, 90%, before we walk into the court, what percentage in your mind do you feel that we will do? Okay? Okay.
Son.
Did you believe me?
I really don't know.
Look, let me tell you my concern. So we have a habit of human beings, law-abiding citizens, otherwise, who want to stay in the village. And so when you said he seemed guilty, and now you're saying that the president, I'm not understanding why you said he seemed guilty. Why you say
Either side need refresh?
No, Your Honor.
All right. All right, sir, we're going to send you through to the final round of questioning, which will be Monday morning at 9 a.m. You don't need to get here until about 8:30. Report to the jury room, though. That is the final round. We're going to pick the jurors from on Monday. So, a couple of things. If you'll hand your badge to the deputy, you're now a purple dot, which is the final group's color. We call jurors by color because of the number of jurors being called. So call today after 5. We're going to give you a packet with a phone number in it. Call that number after 5 just to confirm that you're supposed to be here on Monday in case something really changes. I don't expect it to. There's also in this packet we're giving you, there's a sequestration packet that explains what it's like being sequestered, gives you suggestions on what you need to bring with you. Because you're being sequestered on Monday, if you're picked, you need to pack and bring your suitcase with you. Just leave it in your car. If you need it, we'll go get it. If not, drive home. And lastly, we have a letter for your employer telling them that you're being called back again. Do you have any questions? No. All right, I'll see you Monday morning. Have a good weekend, sir. You're free to go. Thanks. All right, so next up is juror number 20. Good afternoon, ma'am. How are you? I'm well, thank you. Kind of a uncomfortable situation, I know. Plus, it's freezing in the courtroom. If you need to put that sweater on, feel free. Okay. Yeah, I have no control over the temperature, but when I think it's cold, it's freezing. So we have a few questions for you, but we'll get you out of here as soon as we can, okay? These questions, there aren't any right or wrong answers to them, okay? All we're trying to find out is whether you can do your job as a juror in this case. It's something we need to know, and you need to know it also. So the only correct answer to any of these questions is the truth. Do you have, let me start by asking you, do you have any personal, religious, or moral objections to the death penalty? No? Okay. You indicated you'd heard something about this case before you came to court, is that correct? Right. What do you remember from seeing on the news? Yeah. Okay. So based on what you heard back then, did you form any opinions about whether or not Mr. Loyd is guilty? All right. All jurors have to be able to presume a defendant innocent until and if the state proves them guilty. Can you do that in this case? All right. As I explained to you, in order to even get to a penalty phase, there has to have been a conviction for first-degree murder. All defenses have been rejected. The jury's found the person guilty, first-degree murder, intentionally killing someone. Is there anything about the fact that someone's been convicted of first-degree murder that would cause you to automatically vote for death, listening to nothing else? No mitigators, no aggravators, no nothing. If I add to that that the death of the person who was killed was a police officer, does that change your answer? And if I add to that that there's a prior conviction for the death of a pregnant woman, for the murder of the pregnant woman, does that change your answer? Okay. Florida law doesn't have an automatic death penalty. You have to consider both sentences, life and death. Sit through the penalty phase, like I told you, listen to the aggravators, listen to the mitigators. Really listening, absorbing it, processing it. Can you do that in this case? All right. And then in the jury room, when you're weighing those factors out, the aggravators, the mitigators, everything you've heard throughout the case, if you came to the conclusion that the appropriate sentence was life without parole, could you vote for that? If you came to the conclusion that the appropriate sentence was death, could you vote for that? Any doubt about that? It's not an easy decision. Right, but it's one that you could make if you had to. All right, and I'll repeat, you never required to vote for death. Secondly, the insanity defense. Mr. Loyd has raised that. It's the defense's burden to prove it, but pretend you're at the end of the guilt phase. You're trying to decide whether he's guilty or not. You've heard all the evidence from the state and the defense, and you believe that he was insane at the time of the offense. Would you be able to return a verdict of not guilty by reason of insanity? I talk really fast, don't I? Let me slow down. You're pretending now, okay? It's the end of the guilt phase. All the evidence is in, the state's evidence, the defense's evidence. You're in the jury room, you've thought it all through, you believe he's not guilty by reason of insanity. Can you vote that way? Okay. And then lastly, the murder of Miss Dixon and her unborn child. Can you put that out of your mind when trying to decide if he committed these crimes? Do you have any doubt about that? It can be used in the penalty phase. It cannot be used in the guilt phase. You understand that? All right. Thank you, ma'am. I don't have any other questions for you. Mr. Buxman does, and then Mr. Lenneman. Go ahead, Mr. Buxman.
Thank you, Your Honor. Good afternoon, ma'am. Let's speed this up so you don't freeze. Your jury questionnaire indicated you've been a juror before. Was that here in Orange County? About how long ago? Do you remember if it was a civil or a criminal case? Okay. It could be either, but. Okay. You said it was a one-day trial. Did you, without telling me the verdict, were you informed? Was there anything about that experience that makes you not want to do it? I'll be here. I have a couple questions about the insanity defense that the judge mentioned. That's something that we'll be addressing in the first part of the trial, the guilt phase of the trial. And a couple of personal questions. I apologize for asking knowing you say black. Have either you or close friends or family members had any
I mean, like, maybe like my mom, just like, depression or something like that. I was done.
Do you know that your mom had to go through any kind of treatment, medication to help with that issue? Or do you know?
I think she could like,
Did your mom communicate that issue? Oh, I'm sorry. Based on your statements, I think there are some people in the community that may think that mental health issues. Do you think mental health issues are?
I don't know if it's far.
Okay. Would you be able to pull off judgment, considering here all the evidence dealing with the mental health issues? Did you hear the evidence of whether or state would present evidence of an aggravating factor, that make this murder more egregious. You remember that the judge said that not all first-degree murder cases are eligible to warrant the death penalty. So it's those aggravating factors that make the case eligible for the death penalty if the jury thinks it's okay. So if the state and the penalty of the state present evidence of these aggravating factors to you, and you've heard some of them already, or one of them, be used and proven as an aggravating factor by the jury. And the jury can use that to consider whether the death penalty. Another factor that you've heard is that the defendant has been convicted of a prior murder. You can't use that in a guilt phase, unfortunately. If proven, you can use it for sentencing. That makes sense.
It's confusing, but it does make sense.
It is. It is. There's that distinction. Okay. So if you're in the penalty phase and you start hearing information about these aggravating factors, the victim of a law enforcement officer that has prior murder conviction, that may start swinging your pendulum of what the proper punishment should be more towards the death penalty. No matter how far that pendulum starts swinging over to the death penalty, do you promise that you would be able to hold off judgment as far as what the proper punishment should be until you hear the mitigating evidence presented by the defense? Evidence of the defendant's life, his background, his character, those things. Okay. Do you hold off judgment until you hear that evidence?
Listening to both
Yes.
sides.
Yes. Yeah, I'm really asking for you to be open-minded and listen to everything before you make a final decision. All right. Can you do that even, now this is not the time for us to discuss the actual evidence, the detail of the aggravating factor. That's for the trial. That's the evidence you'll hear from. Can you agree to listen to and fully consider any and all mitigating evidence that's presented to you? Even at the first blush, you may think, that's my mind, mitigating. Hold off, it's not. You hear all the evidence about it. Can you do that regardless of what mitigating circumstances are? Hold on, judgment. Truly consider. Okay. Last couple questions. If you found yourself, after you listen to all the evidence, and weigh the evidence in your own mind, you feel that life was prison was the proper punishment. Back here, deliberating. You, after listening to all the evidence, weighing it, mulling it over, you feel it's death. If you, hypothetical sense, talking to your friends and family, but you, in that situation, you felt that was wrong. You can vote for that. One thought.
I mean, it's not something you can jump out and say.
Do you have any concerns with your ability to actually do that? Is there anything in your background, life experience, belief, anything you can stop you from doing your case? What there is, let me know. Thank you for your time.
Thank you, Mr. Wetzel. Mr. Lenneman, you may reply.
Good afternoon, ma'am. How are you?
Sorry.
Understand completely what you're doing. The way the law works for that. The only decision you as a group, board, have to make is whether you want to aggravating factor. Once that's done as a group, it's all on you. All on you make all the decisions, including the final. Nobody can interfere with that. You make that decision. So for example, then, Mr. Buxton talked about aggravating factors, mitigating factors. You would have to make a decision on whether those aggravating factors make the decision alone. You understand that? In Florida, we require all 12 jurors to agree on that. One juror votes for life, life vote. Okay? And the only other thing I want to talk about is your personal conviction. Are you the type of person that if you believe something wrong, that you're not going to let anyone do anything?
I stand pretty true to my own conviction. I'm not gonna be, I'm not, like a follower, so if I believe something.
Okay, and the reason I ask that is because sometimes what happens is that people are going back and forth. One person has said life, no matter what. There are people who try to hold it on occasion. Okay? So I'm asking you, if you decide something, whatever it is, whatever it is, life or death, you believe in that, and that's your conclusion, are you going to stick to your decision? All right, thank you.
Either side need to approach?
No, Your Honor.
All right, ma'am, we're going to send you through to the final round of questioning in a hopefully warmer courtroom. If you'll give the deputy your badge. All right. You are now a purple juror. I use colors to call jurors back because of the large number, but I can tell you when you're coming back. It's Monday at 9 a.m. You need to be in the jury room by 8:30. So we're going to start the final round of questioning on Monday. We will be picking the jury from that group. So a couple of things. You need to pack a suitcase because if you're picked, you're being sequestered that day. Bring a suitcase with you to the courthouse, leave it in your car. If you don't need it, obviously you're going home. If you need it, we'll make arrangements for you to pick it up. There's, in that packet that you're being handed, there's a jury sequestration packet that tells you about being sequestered, gives you a list of things we suggest you pack and bring with you. There are laundry facilities. You don't need to pack 3 weeks worth of clothes, okay? And there's a letter in there for your employer telling them that you're being called back again. Lastly, there's a slip of paper with a phone number. Call that number today after 5 o'clock just to confirm that you're due back to the courthouse on Monday. Unless you hear otherwise, come back to the courthouse, go to the jury room by 8:30. Do you have any questions? All right, thank you, ma'am. You're free to go for today. I hope you have a good weekend. I'll see you Monday morning. Thank you. Welcome back. All right. Have a few questions for you. There aren't any right or wrong answers to these questions. We're trying to find out if you can do your job as a juror in this case. It's something we all need to know, including you. So the only correct answer is the truth. Let me start with you. We're going to call your employer. Do you get paid for being here for 3 weeks? All right. Do you have any... Oh, you have heard about this case, correct? Can you tell me what you've heard? That's all? Yeah. All right. What do you remember, if anything, about it?
It's sort of like a crime spree. We went from to the mother of the child. Next thing I heard that it was a manhunt for him and then moved off.
Okay. Anything after the officer that you remember? Did you watch a lot of it or just a little bit or what?
Just a little bit. I work overnight. I've been overnight sitting here, so I gotta get my sleep at that time.
Okay. Talk to family or friends or neighbors or coworkers or anybody about this?
No, everybody has their opinion of what happened. I don't know anybody that knows him personally. I don't, so.
Okay. Did you have an opinion about whether or not Mr. Loyd was guilty?
No, I don't.
All right. You understand you have to presume him to be innocent in order to sit as a juror. Can you do that?
I can.
All right. Do you have any personal, religious, or moral beliefs against the death penalty? All right. Are you a person who believes that if you convict someone of first-degree murder, intentionally killing another person with no legal reason to do so, are you someone who believes that that person should be sentenced to death? Okay. And if I add to that that the person who died is a police officer, does that change your answer in any way, ma'am? If I add that there's a prior conviction for the murder of a pregnant woman, does that change your answer in any way? All right. All of that is Florida law. No automatic sentence. You have to consider aggravators and mitigators. You have to listen with an open mind, process all of that. Do you believe you can do that in this case? And if, at the end of listening to all the evidence in the penalty phase, weighing the aggravators and the mitigators, thinking about everything that happened in the case, you believed the appropriate sentence was life without parole, can you vote for that?
Yes, I could.
All right. If you believe death was the appropriate sentence, could you vote for that? All right. Any doubts about any of it? All right. The insanity defense, Mr. Lloyd's raised it. Defense has to prove it. It's the one time they have to prove something in the guilt phase. Pretend you're at the end of the guilt phase. You've heard all the evidence from the state, all the evidence from the defense. You believe he was insane at the time of the offense. Could you vote not guilty by reason of insanity? All right. Any hesitation about it? All right. And then lastly, the murder of Miss Dixon and her unborn child. As I told you, that has nothing to do with whether he's guilty of these charges or not. Can you put that aside? All right. In the guilt phase, you can consider it in penalty, but you can't consider it in guilt. Can you do that? All right. Thank you, ma'am. I don't have any other questions for you. Mr. Buxman, you may inquire.
Good afternoon, ma'am. How are you doing today? I believe earlier you mentioned that you know the name Monica. Did you actually work with her at the Walmart that you were assigned to?
No, they've already worked together on one Walmart. She transferred to the one with the contact.
Okay, when you worked, but you did work together at one point at Walmart, right?
Before everything happened.
Understood. Did you work closely with her?
So I was a supervisor. Gave her time in.
Okay. Do you know why she was transferred from one Walmart to the other? Did she move, or was it
She had worked there previously, she wanted to go back.
okay? If Ms. Pridgeon were to testify in this case, would you be able to treat her testimony the same as you would anybody else? Would you automatically tend to believe everything she said, or disbelieve everything she said, or you would Did you ever socialize with her outside of work? Okay, so you were her supervisor, you told her what to do, she did it. Okay. Did you ever work at the Walmart where this incident happened? You know any of the people that work at that Walmart? I have a couple questions to start off with about the insanity defense the judge talked about. That is something that's going to be addressed in guilt phase, first part of the trial is whether or not and I do have a couple of rather personal questions about that. I'll try to be brief. I apologize. Do you or a close friend or family member have any experience with mental health?
No.
Okay. Some people in our society, maybe of the opinion that mental health issues are state's going to do is they're going to present evidence of aggravating factors. Or three. And you've heard a few of those things already. Aggravating factors. And you've also heard that the defendant has been previously convicted of a murder of a criminal. That is also an aggravating factor that can be used in sentencing if proven. It can't be used in the guilt phase over here. That's not relevant to the guilt phase. Thank you. Okay. So we're in the penalty phase here. And if you're hearing evidence of these aggravating factors, and this evidence is starting to move your kind of pendulum towards the proper punishment in this case being death, or aggravating factors will be give to those factors. Can you promise me that no matter how far these aggravating factors may bring you over to the death side of the proper punishment, can you agree to listen, not make a decision, just hear the evidence of mitigating circumstances? Can you agree to do that regardless of what mitigating factors are? Can you consider each mitigating factor presented? Can you agree to do that, even if at first blush when you hear it, your first reaction might be, can you hold off judgment until you hear the actual evidence and details surrounding it? That way you can be fully informed. Once the judge indicated to you that at no time you're required. It's not going to be a situation where you get a form, you check off these 5 boxes. If after you hear all this evidence of the aggravating factors and mitigating circumstances, consider it, you weigh it, in your mind, your decision is, in this case, like the president of the on the other hand, if after weighing all the evidence, mulling it over, you think that the death penalty is the proper punishment. Not talking hypothetically or hanging out with friends, talking about it, but you in this situation, would you be able to raise your hand and say, I think I vote for death. Last question. Is there anything in your life, background, belief system that makes you think I might not be able to do this? I don't know if there is not. Okay. Thank you for your time, man. No further questions, all right?
Thank you, Mr. Bruxman. Mr. Lenneman, you may inquire.
So the way the law works is that penalty phase is the jury's individual decision. Second part, at the end of the road, there's a rule that says all 12 juries required to make death. The death penalty is in play. And if one juror votes for life, that's life. It's a very, very powerful thing in the jury to control. Okay? And the law also says you're never required to vote. What the law says is that you have to go through the process. The process consists of you looking at aggravating factors, finding not moving out, weighing those aggravating factors, looking at mitigating factors, show that the proven lesser death, weighing those if you find that the mitigation outweighs the aggravation, you're required to go to trial. But if the aggravation outweighs the mitigation, you may not, not required. The law says in the instruction you read, you are never compelled to vote. So that means that there's a big box there that gives you an opportunity to make a personal decision. There's something else that requires you to vote. Okay? You understand that? That's the law.
either side need to approach?
No, Your Honor.
All right, ma'am. As I see you're handing your badge to the deputy, we're going to send you through to the final round of questioning in this case. We will be picking the jury from that group. We are going to start questioning Monday morning at 9 a.m. You'll need to be in the jury room by 8:30. All right, don't get there at 7:30. 8:30 is plenty of time. Since we're picking the jury on Monday, we're also sequestering the jury on Monday, so you'll need to pack your suitcase before you come and bring it with you. You know, leave it in the car or something, because unless you get picked, you won't need it. We're giving you a package that includes a bunch of things. Number one, it's got a slip that gives you a phone number to call. Call today after 5 just to verify that you're supposed to be here Monday. If you don't hear anything different, you have to be here Monday. You're a purple group now. You're a purple dot. We call jurors by groups because there's too many of you to call by color. So you're listening for purple. And unless you hear purple doesn't need to report Monday, you need to be here Monday, okay? There's a package in there about being sequestered as a juror and what's involved. We have some suggestions for what you need to pack in there. There are laundry services, so you don't need to pack 3 weeks worth of clothes. And there's also a letter for your employer. Do you have any questions? All right, ma'am, you have a wonderful weekend. I'll see you Monday morning. All right, thank you. Okay, folks, that is 60. The remaining jurors may be excused. I will see the attorneys back here at 3:30 for your motions. We'll get through as many of them as we can get through, but I'm not going past 5. So pick your order. I'm going to let you all call the order you want them in. And whatever's left over, I'll work in sometime when I need to. Any questions? 3:30, yeah. It's 1:20. Everybody needs a break and lunch, so, especially me. All right, thanks. Court's in recess. General voir dire, which is, you may not revisit the topics that have already been exhausted during individual voir dire and during hardship unless a juror brings it up. Not because you asked them a question, but because they brought it up spontaneously. Keep your general voir dire limited. All right, thank you. All right. You all have filed a series of motions. State, you filed first, so which ones you want heard in what order? Go.
I have them in order, I can just announce it and we can start it, that's okay?
That's fine.
First one is the state's motion in Lemony regarding arrests of accessories. That's not the exact title, but I think Your Honor knows what I'm referring to. As would be the case, unless Your Honor tells us otherwise, I don't have any additional argument unless Your Honor has questions about what I'm seeking to exclude and why. This motion in particular came from the trial testimony from the first trial, the questions that were asked. We don't believe that the mere fact of the arrest is relevant, particularly not any mental illness that any witnesses have, or whether or not the Office of the State Attorney for the Ninth Circuit filed charges, and we asked all those questions before him.
Response?
Part of this case is...
Mr. Lenneman, you're still required to wear a mask. All right. Okay, good.
So, an issue that is important is that, in this case, is that my client made several statements on wiretap related to the issue of police at least one.
Okay.
Also in the discussion, he talked about why the reason is for him coming back and turning himself in. The state has suggested already through Facebook posting, and I anticipate they'll do otherwise, that my client had a long-term desire to kill police officers. My client ultimately gives himself up. He waves a flag, he calls himself out, and he does that because he wants to give up, and he doesn't feel immediately threatened, and more importantly, he wants to provide the reward to Ms. Dixon's father, who will give it to the children. He says that on the wiretap. He also says that he comes back for his girlfriend, his ex-girlfriend, who was arrested and placed in jail. Ultimately, the case was dropped, but was arrested and placed in jail. So all of that is tied in to the issue of his surrender, his reason to surrender. And by them raising the issue that he's a cold-blooded cop killer, this is evidence that disputes it, the record. Because if that was the case...
How does the arrest of James Slaughter, Ms. Smith Loyd, or any other suspects, other than Mr. Loyd, obviously, but how does the arrest of those folks have anything to do with Mr. Lloyd's motivation for... What you just said is the state's offering it as evidence of motivation to kill a police officer?
What they're offering it for, Judge, you'll see when they present a Facebook post, they're trying to attempt to...
I've read the Facebook post, but that's not what we're arguing about right now. It's the arrest.
It's related to rebuttal to that, to be able to rebut that issue, knowing that if this court lets in any evidence outside of the event that occurred at Walmart, that Mr. Loyd had a propensity or desire or whatever to kill police officers, that we need to be able to rebut that. So he comes from a safe place.
So tell me how the arrest of these folks who eventually were released and weren't charged is related to what you are just saying.
Just the arrest of his ex-girlfriend, not the other two.
Which one is it?
Janice.
Who?
And his niece, he says, Lakentia. So there's two, Lakentia.
Lakentia Smith and who? I have James Slaughter. That's not his niece, right?
No.
Okay. So that has to do with...
It has to do with his state of mind of wanting to surrender. It refutes the idea that he has this long-term goal of killing police officers because he puts whatever freedom he has, and he had freedom because he wasn't even in Orlando at the time, he puts that aside to come in and give himself up to help them out. Because they were arrested basically to draw him out.
State, what's your response, please?
There's no logical tie between those two things. There's just not. I'm not making the connection between Mr. Lloyd's desire, assuming it's true, to help out family members by turning himself in, and whether or not he has a desire to inflict harm on law enforcement. There's no tie. What I suspect would be the use would be to try to paint law enforcement as if they had done something improper by making an arrest of individuals associated with Mr. Lloyd, particularly any individuals who are alleged to have had mental illness. So absent a tie to relevancy in some way, we believe it's inadmissible.
Okay, here's what I'm going to do. I'm excluding it for now, but if you can tie it up during the trial, I'll revisit my ruling, but it's excluded at the moment. All right, next, Mr. Williams, what's up next? So the motion in limine regarding arrest for accessories is granted without prejudice to raise it if a door is open during trial.
Judge, so you're aware, Mr. Lloyd told me just now that he wants to put this up.
Okay, well, we're going to do the motions first because it's 3:30. It's been a really long day and we'll get to it later. Okay, go ahead.
It's part of the motion, so you know, Judge.
Okay, I'll get to it in a little bit. Go ahead, Mr. Williams.
The second motion is the state's motion in limine to exclude self-serving hearsay as a conduit, specifically after Dr. Jeffrey Toomer, who is the defense expert on sanity witness.
Okay, what is it exactly that you're trying to exclude? Because I read the motion, but it doesn't give me any statements. It doesn't tell me anything. So can you tell me exactly what you're trying to exclude?
No, because I don't know exactly what Dr. Toomer is going to say.
Well, that makes it hard for me to rule.
I understand. What I don't want to happen is for Dr. Toomer to get up there and start testifying that Mr. Lloyd told me blah, 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 blah. And I know Your Honor may understand the rules of evidence, but I've been in courtrooms where that has happened and it didn't seem to be a problem. I read defense counsel's response. We agree that if there is evidence that meets an exception or is admissible, Dr. Toomer should be able to discuss it. But the mere fact that something was told to Dr. Toomer, and specifically Mr. Lloyd's statements to Dr. Toomer over the course of interviews, are not admissible and cannot be discussed whenever Dr. Toomer is discussing his testimony. That's the reason for the motion.
All right, so I actually don't need to hear from you on this one. Here's what I'm going to do. Since I have no idea what statements we're talking about, and I'm kind of ruling in a vacuum, I mean, everybody knows what the rules are about conduit, using experts as conduits. So to avoid a huge problem in front of the jury, you're going to proffer Dr. Toomer's testimony. You're going to object along the way. I'm going to rule on it, and then you can call him in front of the jury so that we're all clear on what he can and can't say. Okay? All right, thank you. Next.
The state's notice of intent to use exhibits in reference insanity and open.
Now that one I actually had the time to read. Mr. Lemony, what's your response? I read it. It's pretty. Okay. Well, do you want to add something to it?
Yeah, only that, Judge, there's no question that they're trying to be hard. I don't disagree with the stuff like the video, pictures, photographs, stuff that is coming into the case.
Right.
I don't have a problem with that. I have no objection to them using those, as long as they're saying they're using it in good places. But in terms of the issue of attacking my case, that's the only thing that's confusing. Subtly or otherwise, that is prohibited. Argument is not allowed in open statement.
Are you saying that they can't get up and say, our expert, whoever, there's too many doctors, I can't remember who's testifying to what, but Dr. X is going to testify that he examined Mr. Lloyd and Mr. Lloyd was not insane at the time of this incident? Are you saying they can't say that?
I'm not saying they can't say that. The problem with that, Judge, is it has to be confined to rebuttal. It's a rebuttal witness on the issue of insanity. And both of these doctors, especially the one I just took, is throwing out all kinds of things inaccurately about priors and past behavior and all kinds of stuff. So I don't disagree that they could argue in good faith the general concepts, but they can't relate it to Dr. Toomer or anything that he said, because that's argument.
They can testify, I'm sorry. Good Lord. They can, in opening, just like you can, state to a jury what they believe in good faith their experts are going to say. They can't say, you know, Mr. Loyd is clearly not insane, and our experts are going to testify that he's not. They can't say the first part of that is argument. Our experts are going to testify as follows is standard opening, which you can do also. I'm assuming you're going to get up and say, my experts are, so everybody just stay inside the rules.
My understanding of the motion that he filed is much more expansive.
Mr. Williams, are you planning on going beyond what you expect the testimony to be on the issue of insanity?
No, Your Honor, anything beyond that would be argument, which is impermissible.
Okay. Everybody stay inside the rules. So you can use your exhibits. Well, again, as long as you have a good faith basis for what you believe your experts are going to testify. Same for you, as long as you have a good faith basis, all right? So I guess the motion is...
It was actually, I styled it notice of intent.
Oh, okay.
To give Your Honor a heads up, defense counsel. I don't know that you actually need to do that.
I don't think I need to rule on this, just everybody stay inside the rules. All right, next.
The fourth motion is the state's motion to admit baseball players.
Let's do some of the easier ones and then we'll get, or unless you guys have stipulated on this one.
I don't believe there's stipulation.
All right, let's skip this one and go on to, I'm going to listen to it, but I want to do as many as I can quickly. Go ahead.
Mr. Buxman has a couple of state motions, and then it's just whatever Mr. Lemony's motions are, we're prepared to go on those.
Okay.
Both of mine are penalty-phase motions. I don't know if you want to hear them at this point or not.
Which were your two?
I filed them. We had a hearing on the state's motion to prevent mention of the ACE study, which was branded. The defense has filed a motion to reconsider that.
I was told that that motion was filed. I haven't looked at it. I'll take a look at it in chambers and see if I need a hearing on it or not.
And the other motion that I filed dealt with Dr. Wu's PowerPoints and the use of various slides and citations and references and things.
Well, here's what I need. I need to know specifically which, did you list in the motion specifically which of those you're objecting to?
I did, Your Honor. I laid out in the motion and attached a copy of the PowerPoint itself with the corresponding slide numbers.
That's a different one. Hold on. I have a whole pile here.
Paragraph 3 lays out the specific slides and the specific objections to each of the slides. I didn't realize I missed one slide.
All right, so here's the ones that I have marked as you're objecting to. So tell me if there's any others. And I'm going to refer to them as the page numbers that are on the bottom of these slides attached to the motion. I have page 32, page 33, page 34, and then I have page 48, 49, 50, and 51. And lastly, I have page 52. Did I miss any?
Slide 14.
So is it page 14?
Yes, I'm sorry.
Okay. I didn't know if the slides corresponded to the pages, so, all right.
They did.
Page 14 you're objecting to?
Yes.
Okay, or
Regarding-
slide 14, okay.
18, 21,
Hold on. I gotta mark these, otherwise I won't be able to keep track. So 14,
14,
18,
18, 21, 25,
21, 25. Okay,
16.
16 I already marked, I think. No, go ahead.
And I think I mentioned 18. I think
You did.
that's all of them. I think they are all listed under paragraph 3 of my motion and broken down into collections of under certain topics of why they're inadmissible.
So it's all the ones I mentioned plus the ones you mentioned today.
I believe so, Your Honor, yes.
Okay. And Mr. Lenham, you said you're not ready for this one today?
While we're picking the jury, we received the deposition of our last two experts that take them back to the definitions of minus pages.
Mm-hmm.
I hadn't had a chance to do that yet. We talked to him about this slide.
Okay.
I did forget one slide. The end of slides, or the end of page 17 contains a reference, which I didn't include in my motion. I just noticed it earlier. It contains a reference to the arrest and the losing the vision of his left eye. That's for a different reason.
Okay.
Thank you, Your Honor.
All right, so I'll put this one aside. You'll need to get this done before penalty phase. All right, what's the next one you all have? Is that it for the state? Before, putting aside the Facebook motion for a moment. All right, what happened, what's going on with the mutiny motion, as I call it?
What motion?
The mutiny motion, the aggravator prior violent felony, federal conviction.
So we have an expert who was his own defender.
When's that going to happen? Because this has been going on for a month.
He wasn't available today. He would have been available sometime during the week. He had court issues today all day. So I don't think his testimony is going to be super long. I think we probably can do it all in an hour. Easy.
Okay, because we need to get, this motion's been floating around now for over a month. It's actually been filed for a while, but it's been, coming up for a month, so it needs to get heard. You need to set that one and the Dr. Wu motion for a hearing, and then folks either have witnesses or they don't, but I'll talk to Trina to give you some times for these. Okay,
I
next.
think that any witnesses would be appearing by Zoom anyway.
That's fine, yeah.
Thank you, Your Honor.
He's been deposed?
Yes.
Okay. All right. So, is that it for the state's motions?
It is, yes, Your Honor.
So, I'm going to call up defense motions for rebuttal argument. You have any additional argument to make on that one, Mr. Lenneman? Oh, it's yours. I'm sorry, Mr. Marrero.
No, that's okay. But as far as that argument, the most that occurred to me is asked about the alternate argument that if the court rejects this one, that we get certified on the issue of intent. And I think that would be good. In terms of in closing argument, State would go first, we would go next, State would get rebuttal, and we would get sir rebuttal only on the issue of insanity. We bear the burden.
State.
Compromise has to be based in law, and it's not. He has some hope in my motion.
Yeah, I didn't see any legal, there's no legal basis for it. Motion denied. Okay. And then I have the requested jury instruction on the definition of clear and convincing evidence. Who's arguing that one? State.
We object, and more specifically, particularly to eliminating the language that they seek to eliminate from the current standing instruction.
Yeah, the insanity instruction has the definition of clear and convincing evidence. I'm going to deny the requested instruction. And defendant's request for judicial notice or in limine to instruct an expert. Who's arguing that one? Okay.
Essentially what happens is Dr. Gamache believes he knows the law better to say.
Okay, I'm listening.
After you go through the process. Dr. Dimash does not agree with that. His opinion of the law is, as he says it about 15 times.
What exactly is it that he says?
He says that he's not the one, he's not the trier of fact who makes the final decision. So he would never give his ultimate opinion on the issue, that he would reference the insanity provision and go through that. He would never give an ultimate opinion, nor does he believe that anybody with the trier of fact is allowed to do that.
State response.
I think what he would say is that it is the ultimate decision of the trier of fact to make that, reach that conclusion, which I believe is an accurate statement of the law. I won't ask him that. He said it multiple times because Mr. Linneman asked him multiple times and it was back and forth. So my intention is to just have Dr. Dimash stay away from it, state his opinion, and it's not going to be an issue. But even though I don't think his opinion is legally incorrect.
Well, the ultimate decision belongs to the jury as to whether or not Mr. Loyd was insane at the time of the offense. That's a jury call.
Yes, Your Honor.
Just stay off this, is what you're planning on doing?
It is, Judge.
Okay. All right. What other defense motions are there?
This is the Wheeler issue, which focuses on penalty.
When did you file? You have got to stop filing these late motions, all right? You're outside the time for filing motions. So what motion are you talking about?
It wasn't late, Judge. It was last week's, while we're in the middle of litigation.
Oh, that one I'll deal with in chambers. Okay. You talking about the use of force motion?
Yes.
That one I'll deal with in chambers.
You have some additional arguments.
Go ahead.
Number one, that this evidence is usable in the docket for the reconstruction of the death penalty, defendant's mitigation. It's the same type of evidence that was committed in the Wheeler. That as a matter of law, if someone lost their left eye before this trial began, the judge would have to agree that it's inadmissible for mitigation. And that's exactly what happened.
I'm going to deal with this one in chambers. All I'm going to say is I think there's been a misunderstanding of what, I mean, you're talking about use of force in here. You can always have someone testify that Mr. Loyd lost his eye, or he doesn't have an eye. I'm going to issue a ruling. You'll get something from me. Okay. Before penalty phase. All right. Anything else? Okay. Facebook account. Go ahead, Ms. Murray. I thought you guys told me you stipulated to something about this.
I believe the stipulation to the authentication of the Facebook records themselves,
Okay.
not to the admissibility of the content.
So to be very clear, no one is saying this is not Mr. Loyd's Facebook account and he's not the person posting this, correct?
That is my understanding.
Mr. Lenneman, is that the understanding? This is, you all are stipulating that these posts that are offered, they're attached as Exhibit A to the motion, regardless of whether they're in or out, but you all are stipulating that this is Mr. Loyd's Facebook account and he posted this?
Yes.
Okay.
Well, he posted the one that identified him.
Right. Yeah. I mean, the responses are clearly not him, but I'm just saying. All right. So so much for the stipulation. Mr. Williams, what are you all offering this for?
Mr. Lloyd's intent to kill.
Okay. These are posts from 2014, 2016. The incident occurred in 2017. So what's your argument?
My argument is the site is close to cases that are in the motion, Buchanan and McVeigh,
Mhm.
one of which I think is McVeigh, where the Supreme Court admitted statements, incidents made and committed by the defendant 2 years prior to the actual murder. There are a number of posts that we're seeking admission to. The oldest is 2 years prior to the murder, because I believe it was late summer of 2014 versus January of 2017. More recent ones are within a 6-month time frame of Mr. Loyd committing the murder. We have to prove intent, commit murder, and motive, and that's what both of Buchanan and McVeigh statements go to. I fail to see how Mr. Loyd's statements about murdering police officers and encouraging others to do so would not be relevant in the case for the murder of police officers, even the ones that are 2 years old. And I understand the court's remoteness concern, which is why I made sure to cite the case that I found that had that time frame. I think at a minimum, the statements that are within a tighter time frame, 6 months to a year, are clearly admissible. And I think, frankly, Your Honor, that all of them would be admissible should Mr. Loyd raise a self-defense claim in any way whatsoever. He was acting to defend himself, because this would obviously rebut any claim that he would make that he was defending himself on the
Thank you. Response?
Yeah, Judge, I agree with you in terms of remoteness. I think that the state is misinterpreting what
Mr. Lennon, you need to stand. I can't hear you.
he's saying in those posts. That I think is distinguishable from the court's decision that you cite. And I think clearly under 403 I mean, he labeled them, one with corrections, one with kill, and the other one was.
What are you talking about? I'm not following. He labeled what? Who labeled what?
He labeled them Mr. Williams.
Oh, okay.
He labeled them, one with kill, one with corrections, and we're trying to look at the other one was admit records, guilt.
I can probably clarify that.
That would be helpful. Yeah.
So there were, as I referenced in the motion, tens of thousands of pages of Facebook records. So I picked out the specific posts that we intended to use, and I sent them to Mr. Lennon.
Okay.
You only have 2 of the 3 sets, because the third set is only relevant to the county.
Okay.
And that deals with corrections officers in regards to the mutiny Mr. Oxman's argument.
Okay.
That's why you don't know, because you don't have them in front of you.
That's why I couldn't follow this. I'm thinking, I don't have all this. Yeah. Okay.
There are 2 sets of Facebook posts, however, that are part of my motion, and I delineated between the 2 different.
Well, Exhibit A appears to be comments about police officers.
Yes, Your Honor.
And there's one comment about judges, and then there was one comment that appeared to be sexual. It doesn't seem to have any relevance to anything.
Mr. Loyd says he will not go back to prison. It's irrelevant to that statement. And that's the second half of the state's motion.
Okay, that's Exhibit B.
That's Exhibit B. That's correct.
That clarifies it somewhat.
Yes, Your Honor.
I couldn't find exhibit any other.
I agree that that motion does not support his intention to kill an officer and his motive to
Okay.
avoid arrest in this case.
So B is avoiding arrest.
Yes, Your Honor.
Okay. So just to make sure that Exhibit A, you're telling me the state wants to offer it in their case in chief to go to premeditation and motive.
Yes, Your Honor.
And Exhibit B, you want to offer in your case in chief as avoiding arrest and escape.
The motive. Yes, Your Honor.
Or motive, okay. All right, thank you, Mr. Loyd. Anything else you wanted to add to your argument?
No, Your Honor.
Mr. Lenneman?
Yeah, Judge, in consideration, I think the court is required to review the evidence. I'd ask the court that they haven't, at this point, reviewed the opinion of the shooting. It is important because when floor, they got shoes on the floor, you penetrated the floor, none of that happened. So I think that what you're throwing out there is clearly 403 based stuff to try to bootstrap facts that aren't there. There was a shootout that occurred, Judge. She has 8 or 9 casings around her. And although they're going to get up there and argue that he executed her, any person who watches that video can tell there's a shootout going on between the two. And obviously, our position is that she fired first. And that's what caused Mr. Loyd to draw his gun. And I think the video is consistent. So for them to bootstrap these things that are prejudicial and not relevant, they're doing it to inflame the jury. And that's all that.
Let me ask you a question. This one right here, that article, is that part of the stipulation that Mr. Loyd is the person who posted this?
I don't
It
know.
appears to be him posting it.
He commented.
So he's commenting on this article? Because there's a reference to the article. I didn't know if he posted it or commented on it. Were these all pulled off his Facebook page?
Yes, Your Honor.
So he would have had to post it to comment on it?
That's right.
Okay. All right, I'll take a look at these in detail, and we're going to get a ruling Monday, because we're going to need this for the guilt-based portion of this. When did you all get these Facebook posts?
We've had them for some time. It took some time to go through them. First. Judge, you asked if you would permit, you asked if I had anything else. Mr. Buxman informed me that the remoteness issue, to the extent of attaching to any of the posts before weighed on admissibility. The other thing that I would note is that the argument that is being made is the very reason why these posts are necessary to comply with that. If Mr. Loyd, 6 months, told someone in person that people should rally to kill police officers, and then 6 months later murdered a police officer, I find it hard to believe a court where that would not be admissible. And Facebook has just given us insight into a person's mind.
Okay. I'm going to reserve on this one. I'll get you guys a ruling on it.
So
I just need to take a look at it. What?
So the court is aware of those supplies.
Is the state aware of which ones they are? Two are testifying in guilt or penalty?
That means guilty.
Yeah, I was going to say, so he's testifying as to the insanity defense. And they still don't have the Facebook post? And when are you getting them, the Facebook post?
My intent is to get them this weekend, so the court's aware of this 30,000 pages.
Well, you need to get it to them because we're coming up on trial, folks. This is all extremely late. All right. Any other motions that are pending that I haven't called up?
Not a motion, but an issue that has kind of come up that it gives me concern about guilt phase. We have a witness, the medical examiner that did Sade Dixon's autopsy, Dr. Zadovich. She is in Mexico next week, so I asked Mr. Lenneman if he would be willing to either stipulate to her testimony or allow her to appear by Zoom, because her testimony is going to consist of, in order to try to be consistent with the court's ruling and the parameters that we've discussed, all she's going to do is say, I performed an autopsy on Sade Dixon. During the autopsy, I removed a projectile from her body and introduced the projectile. That projectile was then tied to the firearm. I don't plan on having any discussion with her about any specific injuries, any photos, nothing more than what I just laid out to the court. My understanding is that the defense is planning on objecting to any mention of Sade Dixon's autopsy or the projectile, which in my mind is different than the parameters that we had discussed leading up to this trial.
Well, remind me what parameters. I've discussed so many parameters with you all. Which parameters are we talking about this time?
It was my understanding that basically the entire Sade Dixon incident was going to be coming into evidence, especially since we've now told the jury that Sade Dixon was murdered and a conviction was obtained.
Right.
So therefore, I don't think any evidence of the fact that an autopsy was done and a projectile was removed from her body violates any of that understanding.
So Sade Dixon's coming in. I know the defense wants to argue the weight of that one, and you said that in a prior hearing that you wanted to dispute.
That's penalty.
So it's penalty phase. So the projectile removed from Miss Dixon's body matches the gun and the projectile from
The Walmart shooting.
the Walmart shooting.
We did file the motion to admit that as Williams rule. That was denied. After your ruling on the Williams rule,
But then, you all appealed. Then you said it doesn't matter because I'm going to bring it all in anyway.
yes. So
what's
that
the
was.
prejudice?
I'm sorry.
I'm sorry. What's the prejudice to the defense?
All right, Judge. My client first wants to remind the court that you denied his evidence. So in order for him to adequately address the entire Dixon issue, he would have needed right to dispute certain issues. Putting that aside, Judge, he has told me numerous times that this has nothing to do with money. Our intent in terms of the Dixon is very narrow, both to my client's state of mind in regards to the issue with police issuing information that was not correct, and him reaching out to his police tribe, and she reached out to the police, and the police basically said, we can't do anything about the fact. I mean, that goes to his state of mind. That's really the narrow issue that we're being offered. It's not being offered for truth. It's being offered for the state of mind, which is continuous of his belief that the police are trying to kill him.
But so let me get this straight, because we had a lengthy hearing about this where you informed the court that you all intended to introduce the Dixon case in the guilt phase of this case. After I had said, nobody can talk about this. The only thing you can talk about is he had an arrest warrant. Then you all had me read stipulated facts to the jury that say that Lieutenant Clayton was approaching Mr. Loyd about his involvement in the Dixon homicide. And now you're saying that you don't want them to introduce the fact that the gun that killed Sade Dixon was the same gun that was used in the killing of Lieutenant Clayton. State,
I just know
what's the purpose of introducing the bullet from Miss, just to get it on the record, what is the purpose of introducing the bullet that was removed from Miss Dixon? So I'm sure that I understand what you all are saying.
Yes, ma'am. It was fired from the .40 caliber firearm that was used to kill Debra Clayton as well. To prove the identity, he had an arrest warrant for that crime. That gun is tied to the Dixon crime and the Walmart crime. And our plan was to basically call Andrew Harrison, who was the crime scene investigator who processed the Dixon scene,
Okay.
solely to say, I arrived there, I collected 11 shell casings. That's it, because those shell casings were also fired from the same gun.
Okay.
Call Dr. Zadovich to say, I performed an autopsy on Sade Dixon. I removed a projectile, introduced that projectile. And then obviously it would be tied up with Richard Ruth, who was the firearms analyst from FDLE, who said all these things were fired from the gun used to kill Lieutenant Clayton.
So they're establishing through that evidence, Judge, that Mike fired 11 shots. For what purpose is this not? We have a conviction, we agreed to that
Well, the 11 shots were fired at the scene of Lieutenant Clayton's death, which is at
11
Dixon.
shell casings fired from the defendant's
Oh, you're talking about Dixon's 11 shell casings?
Yes. And the last I heard, this was all going to be admissible, and I just want to know what rules we're playing by so we don't run afoul.
So do I, because the last I was told it was all admissible because you all wanted it all in, and the state was going to, Mr. Loyd, not now, and the state was not going to, no, you were not. We'll get to you in a minute, Mr. Loyd. So you told me and told them that all of this was coming in guilt phase after I said none of it was coming in. Then we read a statement to the jury, and now we're going to go backwards again?
I don't think I said all, I said some. Some of it is coming.
Actually, you said almost everything, because I tried to get you to narrow it for me, and you told me almost all of it was going to, you wanted it. The phrase was I just want to talk about all of it, is what you said. And then you said there might be one or two things. Like you told me you didn't want to get into 2 guns versus 1. And so now you're telling me you don't want to get into anything other than there was an arrest warrant. And there's no way I'm going to tell the state they can't talk about it was an arrest warrant for the homicide of Miss Dixon, since we just read a statement to every juror.
Bullets, in fact, that we shot from the same gun. We already concluded that was
In the guilt phase. So I don't think we need to talk about the 11 shell casings in the guilt phase. However, if you all start talking about all this stuff, it's all coming in. All right? Enough already. So you can put in that the bullet that was removed from her matches the gun that was used in Clayton, because it all ties to why Lieutenant Clayton was attempting to arrest him, and to the arrest warrant, and to the whole scene that was going on. So I have no issue with the medical examiner testifying that there is a bullet removed from Sade Dixon that matches the gun that was used in the shooting of Lieutenant Clayton.
Okay.
I don't know why you need to tell them that there's 11 in the guilt phase. We'll see how far it goes in the in the penalty phase. The circumstances surrounding the shooting are may or may not be admissible.
Okay. To the original issue that brought this up, Dr. Zadovich is going to be in Mexico. I'm requesting to allow her to testify by Zoom for that very limited piece of information.
That is true, that is what we were talking about when this all started. Do you have an objection to her testifying by Zoom? To say that the bullet that was removed from Ms. Dixon matches the gun that was, that she removed a bullet, and then eventually the forensic expert's going to say it matches the bullets, it matches the gun that shot Lieutenant Clayton. Do you object to her testifying by Zoom is the question. All right, so I've overruled your objection to her testifying. What? You need to stand when addressing the court.
in a position where my client is substantially assisting in his representation. And so there are certain things that I believe I have to adhere to in requesting. One of them is that he does not want me to continue.
He does not want you to agree to what? I'm sorry.
That she can do it.
Okay, that, I understand that you are not agreeing to it. I don't see any prejudice to you all to her testifying. You have her previous trial testimony. Her testimony is, she's also more than 100 miles outside the jurisdiction of the court at this point, since she's going to be in Mexico. All she's testifying to is a bullet that was removed from Ms. Dixon. State?
That's it, Your Honor. That's all she's testifying.
All right, so the motion to have her testify by Zoom is granted. Don't bring up the 11 shell cases in the guilt phase, okay? Anything else I needed to rule on? Because this is just wandering.
I don't know, Dominique Daniels. I'll defer to Mr. Williams on that one since.
All right, who's Dominique Daniels, remind me?
Miss Dixon's younger brother.
Okay.
So it,
The one that, not the one that was shot,
correct,
the one that was inside the house.
correct.
Okay, go ahead.
based upon the prior understanding, the state's intention was to call Mr. Daniels to say that he encountered, if you recall his trial testimony from the first trial, he encountered Mr. Loyd outside, he heard gunshots, he ran to the door, he saw Mr. Loyd fleeing. If we're not going to be permitted to do that, I certainly need to know that before I stand up and opening statements. But it is not the brother that was shot. It is the brother that witnessed Mr. Loyd in the yard and then
Right.
flight from the yard.
Well, based on what I'm being told today, that's not going to be brought up by the defense during guilt phase. Is that correct? All right, tell me exactly, so because the state has to know what they can and can't say in closings and or in openings. And quite frankly, this has changed several times. I want to know exactly what you are going to say about Miss Dixon's murder in the guilt phase of this trial.
One reason is that there was a gun found in the yard.
In what yard?
The yard of the shooting.
Okay, go ahead. Let me listen to all this.
And then when my client found out that they were publishing reports, and he intentionally went up to the door and shot her in cold blood, he reached out to his niece, who reached out to Savelli and told them basically that, you know, what's going on with these lies, why are you publishing this? Savelli basically says that he can't control what they do. And so my client, of course, had mentioned that he was willing to turn himself in if they did that. They corrected the wrong. And when they are not correcting the wrong, my client is reaching a heightened state regarding his belief that the police really killed him. So he believes that this was all done intentionally so the police could kill him. And that's important to the state of mind of my client. As it continues through, and we will have evidence that occurs before the
State.
So if I understand it correctly, the defense wants to bring out specifics of what was located at the Long Peak Drive Dixon scene, specifically the gun, and portray that a false narrative was portrayed or was released, but the state is unable to fix that false narrative and unable to bring in the fact that there were 11 shell casings on scene. I mean,
No, I'm not going to allow that. That's where we're at halt. If you want to argue that a gun belonging to Miss Dixon was found in the yard and that the police were putting out a false narrative that it was Mr. Loyd who was the aggressor in that, and I'm paraphrasing this, okay? Then the state gets to rebut that in guilt.
We have absolute proof because we have the
Mr. Lenneman, I'm not going to argue whether you have proof or don't have proof, but what you can't do is stand up in openings and say all this stuff with the state being handicapped, unable to respond. So the state can respond to them saying there's a gun in the yard and that it's a false narrative that Mr. Loyd was the aggressor. Okay?
Does that include the state being able to respond that 11 shell casings were found at the scene?
Yes.
Thank you.
That belong to the gun, because that goes directly to the issue of whether the narrative was false or not.
Thank you.
Yes. And I'm done with this. All right.
proof.
Are we done with the motions?
I believe so.
All right, Mr. Loyd, go ahead.
I want to put this on record. What I told my attorney, what I wanted to present from the Dixon case was the lie that was told to the news, that I came over here, bammed on the door, and gunned these people down. That was completely lie. You was the judge in the trial, so you know that's a lie. That was a complete lie. I reached out to my niece, and I told my niece that this didn't happen like that. This girl put a gun on me, her brother attacked me. I said, talk to the investigator, which I talked to whoever up pegging. He said during the investigation, during the interrogation, and I told him I would turn myself in if they get the news to retract a lie that they done told the whole world, why are they lying? They trying to kill me. And they told my niece they are not responsible for what the news played. But come to find out, it's reports that they are responsible for what the news plays. So now, when I find that out, now I know it's the police that's setting me up and trying to kill me. At first, I thought Sade's mom and them removed the gun and stuff off the crime scene that Sade went and got when it got on me. So now I know it's the police that set me up, because if I'm an investigator and I have this alleged murderer telling me he would turn himself in if I retract a lie at the news play and I know it's a lie, I would hold a press conference and retract the lie that had this alleged murderer turn himself in. But they told my niece, which told me they had. Well, excuse me, I'm gonna get up.
You need to calm down.
No, cause I got to stutter. I stutter anyway.
Just calm down and tell me calmly what it is you want to tell me.
So,
Mr. Loyd, you are being allowed to present that to the jury. The conversation that we are having is not about you presenting that to the jury, but what the state can say in response to that.
So now, back to what I said, the only thing what I wanted my turn, what I told them was the news reported I came over here, bammed on these people's door, and gunned these people down when they answered it. And that's a complete lie. Everyone seen my trial. And the investigator knew it was a lie, but they the ones reported this lie so they can put their framework in play to kill me when they run down on me. And I talked to them through my niece, and I told them, I believe y'all are trying to kill me while y'all are lying. What you lying for? They kill us for nothing. They kill us with our hands up. So now you put out this false narrative. So now the public, when you run down on me and kill me, it won't be no uproar in the community, because they done created this monster which never existed. So now I'm telling my niece to tell her I will turn myself in, but they tell my niece they're not responsible for the news play. So now I know it's them that's doing it. So now I send my niece to the news people. I said, go talk to the news people, talk to them. I'm like, man, y'all got to talk. Somebody got to say something. I send my niece to the news people, and she tell the news people whatever she tell them, and then they have this interview or whatever, and I call them, I'm like, what's happening, what's going on? She started crying, and she was hysterical. She's like, Uncle Keith, they play what they want to play. They play what they want to play. I'm like, man, fuck it, these crackers trying to kill me. So now I'm laying low, so now I'm out, I'm trying to get my people to talk, but everybody's scared to say anything. I was trying to, Walmart never had to happen, but these are the same investigators. These are the same investigators that were setting my niece up, setting my ex up, setting my family. These are the same ones that say they're not responsible for the news play. These are the same ones that lied to me, and that's why they want to exclude these investigators right here from us from saying anything, because they are a bunch of liars, and it's been proven. In my first trial, it's been proven. They lied on my niece. They lied on my ex. They was lying on me. And they the ones set this lie up. Walmart never had to happen. So they trying to evade it. No, I was trying to turn myself in twice before Walmart. And even after Walmart, the third time, I was turning myself in. These clowns didn't find me. I was turning myself in on the phone call, talking to my people, trying to turn myself in, because they were setting my ex up, which has a mental disability, and I know how the system works. They would drag her in these courtrooms and give her a life sentence for something she had nothing to do. And so before I let her do that, I'll die. So I came, and I still, when I was turning myself in, when they came to the house, even when I came to the door, I got low. So now I was telling them to get these other investigators, but they haven't done yet either. When I was turning myself in, when they came to the house, I got low, I got small. So they start opening fire on me.
Calm down, Mr. Loyd. Take a deep breath.
My belief of them not trying to kill me, it didn't go away. But for my people, I die. I don't care. I will die for my people. So I'm not finna not let my ex or my people come here and do no life sentence for nothing they had nothing to do with. So that's why I came back. For my people, I die about my people. It ain't about, oh, I'm trying to kill cops. That's a fucking lie. But when cops killing us, I speak out. I'm not doing none of that.
All right. I've got it, Mr. Loyd. All right. Thank you very much. Everyone has my rulings. I have a reserved ruling on the Facebook motion. What was the other one I reserved on? I made a note.
Use of force.
The rehearing on the use of force. I'll take care of those in chambers. Is there any Anything else, Ms.?
Mr. Loyd said on the record a few moments ago he wanted to represent himself. It's the state's position that you really need to address that.
Oh, yeah, he did. Thanks. Mr. Loyd, do you, well, first of all, I'm not doing a Nelson hearing because the trial has begun. There's a jury's venire has been sworn. So, Mr. Loyd, do you want to represent yourself? You want to keep your lawyers?
Yes, I want to represent myself.
So you want to fire your 2 lawyers?
No, I want to be first chair, second chair, how I had it for last time. And since Sherry know everything, I got to keep Terry.
Okay. And what is the reason that you want to represent yourself?
Because things are being done and it's not being done right, and my life is on the line. They're just like, even with the situation, and I told them I only want the fact for my mind, it was my mind state that the police was trying to kill me. They reported I came over here to my child's mother's house, banged on the door, and gunned these people down. That never happened. Everyone's seen my trial, so y'all know a fact.
Mr. Loyd, focus on what we're talking about. So you don't like the rulings that the court is making, or you don't like?
I don't like the ruling the court is making and the arguments and the stuff that's being put forth on this side, because it's not. I'm upset right now. I can't even talk good right now, and I can't talk no more. I'm upset.
Okay. Anything else about representing yourself? Mr. Lenneman, would you or Mr. Marrero care to put anything on the record as to that? All right. Mr. Loyd, we've been down this road before. You asked to represent yourself. I granted your motion. You struggled. You then asked me to appoint Mr. Marrero as co-counsel. As I've repeatedly explained to you, you are not an attorney. You are not lead counsel. I did that. I appointed Mr. Marrero as co-counsel. You then told me that you could not represent yourself because of the restrictions that you have, because you are an inmate and you were unable to effectively represent yourself, and therefore asked me to reappoint Mr. Lenneman as your attorneys, and I did that. The case law is clear that while defendants have the right to represent themselves, they do not have the right to go back and forth. You can't decide that you want to represent yourself, then you don't want to represent yourself, then you want to have an attorney, then you don't want to have an attorney, then you want to have co-counsel. The court has observed and acknowledges the following, which is that, quite frankly, sir, you are an inmate. You were unable to effectively represent yourself the first time I granted it, and nothing has changed at all in your situation. The motion to proceed pro se is denied. You continue to have lawyers, and you continue to be allowed, as you have been throughout these proceedings, to actively participate in your defense. The court has given you the opportunity to speak when you've wanted to. I have observed, as has everyone in the courtroom, that your attorneys take direction from you. When you want something done, they stop and they do it. So the motion to represent yourself is denied. We are here on Monday morning, courtroom 23, for jury selection. Anything further from the state?
Nothing, they can't wait till Monday.
Is there something you want to talk about now?
Your Honor, I fail to see how, there's 2 issues. Number one, it is very unclear to me, probably doing the opening statement, what I can say and not say, but I will do my best to deal with that over the weekend and address it on Monday. The second thing is, I know we've been talking about what defense counsel plans to present, but I'm uncomfortable with defense counsel discussing any of what Mr. Loyd just discussed in opening statements, because I don't see how it's relevant or admissible. So while it may become relevant or admissible during the trial, and I don't want to object in front of the jury during opening statements. It's not my style to do that and interrupt. So I would like to know again, and I know it's difficult for Your Honor because the sands are shifting for all of us, but I would prefer to not have to object during Mr. Lenneman's opening when he's going to testify to something that may or may not be admissible at all.
And while I understand the position you're in, the court is also in a position that is a bit, my hands are a bit tied in that the defense has the right to present their defense during the guilt phase. The court cannot interfere with that so long as they're not trying to do something that's completely inadmissible. the defense's the defense in this case has some fluidity to it. Let me phrase it that way. And that the court is not completely certain exactly what witnesses are going to say or exactly what the defense is going to be. I understand that there's going to be a defense of insanity raised. But there seem to have been some changes, which is not unheard of, in the defense. And at one point, there was some talk of self-defense, sort of, but as part of the insanity defense. So I can do one of two things. I can tell you, object when it comes up, because I don't particularly care for interruptions during openings and closings, except when someone is clearly doing something that needs to be objected to. Or I can simply say, no one's going to talk about Sade Dixon in opening, period. There will be no discussion from anyone about Sade Dixon in opening until and if I hear testimony from the bench. And quite frankly, that is something I'm actually considering so that we can just end this.
Is Your Honor asking our opinion?
Not really, but I have a feeling that you desperately want to give it to me, Mr. Williams.
We would prefer the latter, with the understanding, my understanding is that we're still permitted to say that Mr. Loyd had a warrant for first-degree murder.
Yes.
But the state's intention, based upon the court's statements, I'm interpreting as a potential ruling, is that we would not address that murder at all, other than to say Mr. Loyd had a warrant in opening statements to make the playing field level as it can be.
Mr. Lenneman, your response to me telling you all, beyond saying he had a warrant for Ms. Dixon's, for the arrest, a warrant for his arrest for the Dixon homicide, nobody's going to talk about Dixon in openings until I hear some testimony from the stand. Because, I mean, quite frankly, Mr. Lenneman, this is an ever-changing situation, and it has become difficult for even me to follow what it is you intend to say in opening. And the state, since you go after the state, it's unfair to the state. So the more I talk, the more I'm leaning towards nobody's talking about Dixon other than to say there was a warrant for his arrest. So I'm going to give you a minute to think about it and talk to your client.
Today, I spoke to my client, and we're in agreement. The only part of Dixon that we is that he discovered that Wes was lying, he went over there and shot her in the foot wall. He found that out. He reached out for his niece. He reached out to the prosecution police. She gave a couple of press interviews, which my client was distorted, and I don't know if we can move with that. Yeah, so, and then in response to her reaching out to the police, they told her they're not responsible for what did by the press. And then based on all that, my client's state of mind was that's the part of Dixon that I plan on introducing. I don't plan on getting into any other part of Dixon, the case. Other than that.
However, by saying that your client, I think your terminology was, didn't gun her down in cold blood. Is that what you just said?
No, what they
Gun her
report
down.
is that he goes to the door, she opens the door, and shoots her at the door. That was the information that was for the general.
The state can then, in their opening, rebut that. They can present what, in their opening, evidence that would be contrary to what you just said if you intend to use that in the guilt phase of this trial. Because you cannot just stand up and make statements and expect that the state doesn't get to introduce evidence to the contrary.
Well, first of all, there's no evidence that supports the contrary. We have 3 press reports.
We have a conviction for let me make myself clear to everyone here, okay? I'm going to let you present your defense. Mr. Loyd was convicted of murdering Miss Dixon, her unborn child, and the attempted murder of her brother, her mother, and I think the other brother. I can't even remember. It was 5 counts. That case was PCA'd. It's a done deal. We are not relitigating his guilt, all right? But if he's going to stand up and claim, if you're going to stand up and claim on his behalf in openings that he did not murder Miss Dixon, the state gets to talk about it in their opening.
And then whenever they open the door, we then get to talk.
Correct.
All right, then it's going to be a free-for-all.
I still may tell all of you that you can't talk about Dixon in opening, all right?
We'll be prepared, Judge.
It's been an extremely long day, and I never make decisions at the end of days like this, but both sides should be prepared to be told on Monday, you will not mention Sade Dixon in opening other than to say there was a warrant for the arrest in her homicide, and that's it. And then I'll see what happens during the trial, okay? Just be prepared for that. Thank you, folks. It's court's in recess. Everybody have a good weekend. See you Monday.